国台办投诉协调局副局长梅红女士，中华全国律师协会会长王俊峰先生，国际投资争端解决中心调解员、西安交通大学法学院院长尚文华先生。连线参加今天开幕式的还有来自有关国际组织和仲裁机构的负责人，他们是联合国国际贸易法委员会秘书长安娜·乔宾·布莱特女士，世界银行副行长、国际投资争端解决中心秘书长梅格·金尼尔女士，国际商事仲裁理事会主席露西·里德女士，国际商会仲裁院主席埃利克斯·希斯·莫里先生，香港国际仲裁中心联合主席袁国强先生，新加坡国际仲裁中心仲裁院院长加里·梅恩先生，开罗区域国际商事仲裁中心主任伊斯梅尔·塞利姆先生，巴基斯坦国际投资及商事仲裁中心主席拉纳·萨贾德先生。此外，还有国内外其他仲裁机构负责人和代表中国贸仲委仲裁员。由于时间有限，在此就不一一介绍了。让我们以热烈的掌声对各位领导和嘉宾的到来，对论坛的各位参与者表示欢迎。借此机会，我代表主办方对国际投资争端解决中心、中华全国律师协会作为本届论坛共同主办方给予的大力支持和协助，表示衷心的感谢。下面，让我们掌声欢迎中国国际贸易促进委员会会长高燕女士致辞。
尊敬的最高人民法院副院长杨万民先生，尊敬的联合国贸法会秘书长安娜女士，尊敬的世界银行副行长、国际争端解决中心秘书长梅格女士，尊敬的国际商事仲裁理事会主席露西女士，尊敬的商务部部长助理李成刚先生，各位嘉宾、女士们、先生们、朋友们，大家上午好。很高兴和来自全球线上线下的各界朋友相聚在2020中国仲裁高峰论坛。在此，我代表中国国际贸易促进委员会、中国国际经济贸易仲裁委员会，向与会的所有嘉宾表示热烈欢迎，向新老朋友致以衷心感谢和诚挚问候。当今世界正经历100年未有之大变局，新冠疫情全球大流行加速了大变局的演进，给全球经济带来了前所未有的挑战。在这个特殊的历史时刻，本届中国仲裁高峰论坛聚集国际仲裁法律界顶级专家，围绕疫情下争端解决的核心与发展这一主题，共同研讨国际争端解决的新形势、新挑战，“一带一路”国际仲裁合作与疫情应对，以及线上开庭仲裁实践的创新发展等国际仲裁热点问题，体现了国际仲裁界应对疫情加强交流的共同愿望，传递了国际仲裁界凝聚合力、共谋发展的美好愿景，对推动国际仲裁发展、促进全球经济稳定 将起到积极作用。当前，中国正在推进全面深化改革和更高水平对外开放，积极顺应经济全球化时代要求，为世界经济发展注入强劲动力。在推进全面形成对外开放新格局中，中国十分重视法治建设和国际法治领域合作，努力推动构建公正、合理、透明的国际法治经贸规则秩序。法治是最好的营商环境，国际化专业化的仲裁服务是国家治理体系和法治建设不可或缺的重要组成部分，对完善市场化、法治化、国际化营商环境发挥着重要作用。中国仲裁机构在服务更高水平对外开放和推进全面依法治国战略布局中奋发有为，开拓创新，取得了长足进步，越来越被国际社会所关注和认可。与此同时，中国不断推出商事仲裁争议解决的对外开放新举措，允许境外知名仲裁机构、争议解决机构经有关部门登记备案后，在中国内地特定区域设立业务机构，并就国际商事、海事投资领域发生的民商事争议开展仲裁业务。人民法院加大支持和监督仲裁力度，积极营造仲裁友好型的司法监督环境，这些都为中国仲裁高质量发展提供了良好机遇和环境。贸仲委作为中国最早成立的仲裁争议解决机构，60多年来始终致力于国际仲裁的发展，推动中国加入纽约公约，参加联合国贸法会、国际仲裁、商事调解等重要工作，积极开展国际仲裁交流，已经和70多个仲裁机构签订了合作协议，独立公正地审理了国内外仲裁案件4万多件，案件当事人涉及100多个国家和地区，仲裁裁决在世界范围内得到广泛执行。2019年度受案数量达3333件，标的额超过1200亿元人民币，受理案件的数量、标的额、当事人国别数均位居国际知名仲裁机构前列，其中受案标的额约占全国253家仲裁机构总量的1/7。贸仲委的仲裁服务赢得了中外当事人的普遍认可，成为国际知名国际仲裁机构之一。面向未来，中国仲裁要紧跟经济全球化、一带一路建设的时代要求，在机遇中谋发展，在挑战中求变革，逐步形成与国际先进规则相衔接的制度体系和要素供给体系，不断改革创新，增进国际交流，打造合作新平台，增添发展新动力，推动国际仲裁更广泛的运用和更高质量的发展。在此，我提出几点思考：一是坚持国际仲裁抗疫合作，促进世界经济复苏回暖。当前，全球范围新冠肺炎疫情尚未得到全面控制，国际仲裁发展面临着前所未有的机遇和挑战。团结协作，相互支持，才能应对各种全球性风险危机。今年，在世界银行国际投资争端解决中心等国际仲裁机构共同倡议下，13家国际主要仲裁机构已联合发起国际仲裁与新冠疫情倡议，中国贸仲委也应邀成为共同倡议方。这彰显了国际仲裁界的远见卓识和责任担当、合规性，提升仲裁数字 子化、智能化，推动国际仲裁高效率、低成本，构建各国比较优势，发挥联合国国际公约的统一性作用，促进国际仲裁融合发展，保障国际仲裁公平公正，努力构建更加稳定、公平、透明、可预期的全球治理环境。三是推动共建“一带一路”高质量发展，开创国际仲裁广阔前景。新冠肺炎疫情给全球经济带来了巨大冲击，推进“一带一路”高质量发展，将为世界经济注入新的活力，为国际仲裁发展提供广阔市场空间。去年，中国贸仲委和40多家中外仲裁机构共同发起“一带一路”仲裁机构北京联合宣言，以共商共建共享为宗旨，搭建新型法治合作平台，提升国际仲裁解决“一带一路”商事争议的功能作用，创新最佳实践，促进国际仲裁发展。我们要继续坚持北京联合宣言的合作理念，细化合作措施，深化合作成果，努力形成更加包容、更为务实、积极有效的交流合作平台，凝聚智慧力量，促进共同发展，努力开创互利共赢的崭新局面。各位同仁，我们要站在历史新的更高起点上，勇于创新，开拓进取，不断创造发展奇迹，为世界带来发展机遇。中国贸促会作为中国最大的贸易投资促进机构和商会组织，持续推进贸易投资自由化便利化和国际国内营商环境优化完善，积极推进仲裁、调解、多元化纠纷解决机制建设，为商事争端预防和解决不断做出新努力。我们愿同国际工商界、国际仲裁法律界和社会各界一道，共同推动国际仲裁争议解决领域的合作，深化交流，增进互信，分享有益经验，以开放共享、互学互鉴、互利共赢的精神，携手前行，为完善全球治理体系、构建人类命运共同体做出更大的贡献。最后，预祝本次论坛取得丰硕成果，祝各位嘉宾家庭幸福、平安、健康。谢谢。
感谢高阳会长的精彩致辞。中国正在持续推进高水平的对外开放、法治建设和国际法治领域合作尤为重要，仲裁在其中发挥着不可或缺的作用。感谢高阳会长为推动国际仲裁高质量发展提出的重要建议。下面，让我们掌声欢迎最高人民法院副院长杨万明先生致辞。
尊敬的高会长、李部长助理、卢副会长，尊敬的各位嘉宾、女士们、先生们，大家上午好。很高兴参加2020中国仲裁高峰论坛。首先，我代表最高人民法院和周向院长，对本次论坛的成功举办表示祝贺，向出席论坛的中外嘉宾表示诚挚的欢迎。这次高峰论坛由中国国际贸易仲裁委员会、国际投资争端解决中心和中华全国律师协会共同主办，规模大、规格高，中外专家和代表线上线下共 共聚一堂，聚焦当前疫情形势下国际争端解决的新形势、新挑战，研究探讨国际仲裁合作与疫情的应对，以及特殊形势下仲裁实践的创新发展，具有非同寻常的重要意义。新冠肺炎疫情在全球的迅速蔓延，给人们的正常生产生活造成了极大的冲击。无论是对国际商事仲裁，还是对国际商事的诉讼而言，疫情的影响都是多方面的。疫情防控期间，全国各级法院坚持以节约高效、多元解分、便民利民、智慧精准、开放互动、交融共享为目标，推动一站式诉讼服务体系建设，通过移动微法院等平台畅通网上诉讼渠道，提供类案、交费、开庭、调解、送达等全方位的服务，克服了疫情对审判执行工作带来的不利影响。数字化沟通带来了庭审的便捷性、低成本、高效率等优势，这些优势被越来越多的司法机关、仲裁机构、律师和当事人认可和接受。最高人民法院国际商事法庭也正在积极建设国际商事案件调解、仲裁、诉讼相互衔接的一站式的纠纷解决信息化平台，通过与法院的诉讼服务平台、移动微法院和仲裁服务平台数据的对接，打通诉讼与调解、仲裁的有机衔接线上渠道，逐步实现类案、送达、调解、庭前证据交换、开庭，一直到宣判全流程的网上办理。可以预见，今后网上类案、视频庭审、电话会议、线上材料提交和交换也会成为商事仲裁和诉讼的新常态。因此今年论坛确定的主题，我认为可谓是精准务实，精准地把握了时代潮流，务实回应社会的需求。我们深切期待与会的专家学者能够就此展开深入的讨论，为应对新时代国际仲裁的机遇挑战提供理论支撑和智慧支持。今年以来，最高人民法院一直高度重视统筹推进疫情防控和经济社会发展的司法保障工作，为依法妥善审理涉新冠肺炎疫情的民事案件，最高人民法院陆续发布了3个就是依法妥善审理新冠疫情民事案件若干问题的指导意见，尤其是第3个指导意见，针对受疫情影响较大的涉外商事、海事案件、运输合同纠纷案件的法律适用问题，提出了具体的指导意见，平等保护中外当事人合法权益，营造更加公平透明、可预期的法治化营商环境。今年的2月3号到9月4号期间，全国法院共网上立案454万多件，网上开庭60多万场，网上调解203万次，同比分别增长了54%、800%和299%。电子送达了1290万次，实现了审判执行不停摆，公平正义不止步。应对后疫情时代的挑战，依法妥善化解涉外商事争议，提升仲裁服务能力，提高仲裁的公信力，这是仲裁界面临的重大课题。借这个机会呢，我谈3点看法。第一， 顺应合作共赢时代潮流，提升仲裁服务能力。1958年纽约公约的诞生，极大地促进了国际商事仲裁事业的发展。迄今为止，该公约已有包括中国在内的165个成员国。海牙国际司法会议选择法院协议公约于2015年10月1号生效。联合国关于调解所产生的国际和解协议公约，也就是新加坡调解公约，于今年9月12号也正式生效。中国都签署了上述公约。此外，2019年7月2日，海牙国际司法会议第22届外交大会通过了旨在促进民事商事判决全球流通的海牙判决公约。中国代表团积极参与了该公约的谈判。仲裁、调解、判决、跨境承认和执行领域多个公约在世界范围内的缔结和生效，反映了合作共赢的时代潮流。国际商事争端解决机制得以不断的丰富和完善。中国仲裁机构应当顺应潮流，充分发挥在处理国际贸易、投资纠纷、争议解决优势，遵循仲裁客观规律，尊重仲裁规则，尊重当事人的自愿选择，加强行业自律，健全制度机制，高水平参与国际合作，勇于改革创新，总结先行先试的经验，打造具有国际影响力的仲裁品牌，不断提升中国仲裁的国际竞争力、认知度和话语权，满足中外当事人纠纷解决的多元需求。第二，规范仲裁司法审查制度，有力保障仲裁的发展。司法是仲裁坚强的支持者和守护者。仲裁程序的顺利进行，仲裁协议和仲裁裁决的执行，都离不开司法的有力支持。司法对仲裁的支持，又体现为司法对仲裁的监督。当事人在合意选择仲裁解决争议的同时，对于仲裁裁决受司法监督这个制度的约束，有着同样的合意和期待。司法依法对仲裁进行支持和监督，是维护仲裁公正与和裁判执行力的坚强的后盾，更是提高仲裁公信力、促进仲裁业健康长久发展的有力保障。最高人民法院始终高度重视仲裁工作，坚持支持仲裁发展的立场，特别是近年来密集发布了关于仲裁司法审查案件归口管理、报核问题、审理程序和法律适用、办理仲裁裁决执行案件等司法解释和规范性文件，促进司法审查尺度统一。最高人民法院还加强对地方法院仲裁司法审查工作的指导，每年对仲裁司法审查报核案件进行系统的分析和研究，及时发现地方法院在认定仲裁协议无效、不予执行或者撤销仲裁裁决案件中存在的普遍问题，及时予以指导。各级人民法院秉持支持与监督并重理念，一是尽可能对仲裁协议效力做有效解释，充分尊重当事人的仲裁意愿；二是对撤销和不予执行仲裁裁决情形严格把关，在强调司法对仲裁依法监督的基础上，保障仲裁公正；三是严格执行纽约公约，切实履行公约义务，依法承认和执行外国仲裁裁决。这些做法有力保障和促进了仲裁公信力的提升， 下一步，最高法院将结合民法典司法解释的清理工作，对相关仲裁法司法解释以及规范性文件进行清理，通过清理和修改，建立更加系统完备的仲裁司法审查制度体系，进一步营造仲裁友好型的法治环境。第三，发挥仲裁化解争议功能，着力加强研究创新。新冠肺炎疫情全球大流行，这是近100年人类历史上没有过的大事件。因疫情引起的新纠纷、新现象，对涉外商事审判和仲裁都是巨大的挑战。当前，疫情导致合同履行延误或终止等等争议纠纷急剧增加，疫情所涉的生物技术、制药、医药卫生等新问题也此起彼伏。与此同时，境外仲裁组织在上海临港新片区等地经批准设立分支机构，这也给中国国际商事仲裁格局带来了新的气象。仲裁具有公正高效、快捷便利、程序灵活、保密性强等独特的优势。各仲裁机构应当结合新形势，加强交流，互相借鉴，发挥仲裁解决争议的制度优势，共同为人类应对疫情和恢复经济贡献力量。当前这个建议可以研究以下几个问题：一是充分的预估疫情结束以后，特定领域、特定行业案件大量增加，可能给仲裁工作带来的挑战，提前制定工作预案。例如，可以提前收集研究各国不可抗力和情势变更的法律规定，提升外国法律查明的能力。二是研究趋势下如何完善仲裁规则，优化仲裁程序管理。例如，在线仲裁如何保障当事人意思自治和程序公正。三是针对后疫情时代数字经济所涉的新领域、新业态纠纷出现的问题，进行前瞻性的研究。例如，这个数据跨境流动所产生的隐私保护和国家安全问题。我相信国际国内的仲裁界应该并且能够实现更加紧密的协作，更与深度的合作，共同促进创新，推动仲裁事业与时俱进发展。最后，真诚的祝愿中国仲裁机构牢牢把握新时代赋予的契机和重任，吸收优秀人才，完善仲裁规则，创新服务能力，不断提升与扩大中国仲裁品牌的公信力和影响力。人民法院将一如既往的依法履行支持和监督仲裁的司法职能，继续完善仲裁司法审查制度，保障和促进中国仲裁业的发展壮大，共同为纠纷的多元解决创造良好的法治环境。最后，预祝本次论坛取得圆满成功，谢谢大家。
感谢杨万明副院长的精彩致辞。长期以来，最高人民法院一如既往地坚定支持中国仲裁和国际仲裁的健康发展，为营造仲裁友好型司法环境起到了率先垂范的作用，为中国市场化、法治化、国际化营商环境建设提供了更加有力的支持和保障。在此，我们表示诚挚敬意。下面让我们掌声欢迎商务部部长助理李成刚先生致辞。
尊敬的高会长、杨院长、洪启副会长、别交大法官、俊峰会长，在线上的安娜秘书长、麦克秘书长，现场和在线的各位专家、女士们、先生们，大家上午好！很高兴出席2020年中国仲裁高峰论坛。在当前新冠疫情肆虐全球，人类面临前所未有的共同挑战的时刻，我们共同研讨争议解决机制的革新与发展，非常有意义。我代表中国商务部对论坛的成功举行表示热烈祝贺。新冠肺炎疫情是21世纪最为严重的全球公共卫生危机，导致需求下滑、供给收缩、失业上升、预期下降，全球经济陷入二战之后最严重的衰退，经济恶化程度超过2008年金融危机时期。根据 OECD 9月16日发布的经济展望中期报告，2020年第二季度全球产出比2019年降低10%以上，预计2020年全球经济缩水4.5%。2008年全球经济未出现负增长。根据世贸组织的统计，2020年第一季度全球货物出口和进口同比下跌约6.2%和5.3%，预计2020年全球货物贸易额将下跌13%至32%，可能高于2009年22.6%的下降幅度。就中国而言，2020年第一季度国内生产总值同比下降6.8%，第二季度同比增长3.2%。进出口方面，第一季度下降6.4%，上半年下降3.2%，1至8月下降0.6%。利用外资方面，第一季度下降10.8%，上半年下降1.3%，1至8月增长2.6%。中国经济形势逐步回稳向好。疫情给国际商事交易带来巨大冲击，各国纷纷对人员、货物采取限制入境或隔离措施，一些企业被迫停工停产，给合同履行带来很大的不确定性。各经济体在出台经济刺激政策的同时，也采取了许多贸易和投资方面的限制措施。有些措施出台并非出于疫情防控原因，而是出于经济摩擦、地缘政治等方面的考虑。近年来，经济全球化遭遇逆流，保护主义、单边主义盛行，有的国家动辄以所谓国家安全限制，甚至是禁止正常的国际贸易、跨国投资活动。新冠肺炎疫情的流行让这一局面雪上加霜。尤其值得关注的是，国际经贸争端解决机制的权威性受到严重挑战，约束性受到很大减损，国际经贸规则环境的不确定性明显增大。当前，国际经贸争端解决机制面临的主要问题表现在以下几个方面：一是世贸组织上诉机构停摆。2017年以来，美国以存在所谓体制性关注为由，阻挠空缺上诉机构成员遴选。2019年12月，上诉机构因只剩1名法官而无法受理新案件。曾被誉为多边贸易体制皇冠上明珠的上诉机制黯然失色。 上述机构停摆是多边贸易体制遭受的最沉重打击。二是投资者国家间争端解决机制遭遇合法性危机。一方面，对投资仲裁的一些长期批评仍未找到有效的解决方案；另一方面，近年来一些国家基于对国家主权权利和公共政策等方面的考虑，质疑投资仲裁的合法性，选择抛弃投资者与国家间争端解决机制，废止已签署的双边投资协定，退出华盛顿公约。国际投资争端解决机制的未来走向扑朔迷离。三是完善多元化国际商事争议解决制度，任务艰巨。世界早已进入信息时代，电子商务蓬勃发展，日新月异的信息技术催生的新业态、新模式层出不穷，参与商事交易活动的主体规模呈现指数级增长。传统的商事争议解决模式显然难以适应新的形势变化和要求。时代呼吁变革和发展，传统商事争议解决方式有变革的压力，新的争议解决方式有发展的需要。近年来，商事争议网上解决规则的制定与实操的尝试，新加坡调解公约的签署和生效，都是为回应商事争议解决实践需求的积极探索和有效付出。在国际秩序深刻调整、地缘政治热点不断、国际经贸规则面临重塑压力的形势下，中国始终坚持深化改革、扩大开放，积极推动经济全球化，坚持多边主义，坚定维护多边贸易体制。根据相关安排，在国际经贸争端解决领域，商务部具体开展了以下几项工作：积极推动达成世贸组织多方临时上诉仲裁安排。针对世贸组织上述机构陷入僵局的现实，中国与欧盟等世贸成员密切合作，共同建立了多方临时上诉仲裁安排。截至目前，共有50个世贸组织成员参加了该项安排。7月31日，各参加方就仲裁员名单达成一致，成功组建了仲裁员库。该安排作为一种过渡性机制，对于维护多边贸易体制、维护 WTO 争端解决机制的权威性和有效性具有重要意义。积极推动国际投资争端解决机制改革进程。我们积极支持联合国贸法会推动的投资者与国家间争端解决机制改革进程，正式提交了中方改革建议文件，就下一步改革方向提出了中方的建议方案。我们也与解决投资争端国际中心保持着紧密联系和建设性沟通，并积极支持正在进行的规则修改工作。积极推动新加坡调解公约的签署和生效。2020年8月7日，包括中国在内的46个国家签署新加坡调解公约，解决了国际商事调解达成的和解协议的跨境执行问题。目前已有53个国家签署了公约，已有6个国家完成了批准程序，公约已经正式生效。中国政府正在积极研究推进批准公约的相关工作。女士们、先生们，审视当前单边主义、保护主义、霸凌主义抬头并有蔓延之势，经济全球化正遭遇前所未有的挫折，加之100年未见的新冠肺炎疫情仍全球肆虐，全球经济发展受到严重冲击。这似乎是一个最坏的时代。但是，放眼未来， 只要我们敏锐洞察危机中孕育生机，只要我们努力在变革中谋新局，这又何尝不是一个最好的时代？我们认为，中国的商事仲裁制度应始终坚持公平、正义、高效的价值取向。商事仲裁服务应始终秉持以当事人为本的服务理念，锐意改革，不断创新，以持续提高公信力，塑造中国仲裁的核心竞争力，为有效维护交易安全与稳定，促进国际贸易和投资活动的顺利开展做出积极贡献。中国商务部愿意与国际仲裁界、国际法律界一起，推动完善商事仲裁制度，共同营造更加稳定、透明、开放的国际商事法律环境。预祝2020年中国仲裁高峰论坛圆满成功。谢谢。
感谢李成刚部长助理的精彩演讲。商事仲裁在促进和稳定世界经济中发挥着重要作用。成刚部长助理提出，中国仲裁要与时俱进，不断创新，努力提高公信力，为推动构建公正、合理、透明的国际法治、经贸秩序做出积极努力。这也是我们仲裁法律界的一个共同目标。现场致辞呢，就到这里。现在，让我们再次以热烈的掌声，感谢各位领导和嘉宾的精彩致辞。各位朋友，各位同仁，新冠疫情全球蔓延的严峻形势下，国际争端解决面临着变革和挑战。希望全球仲裁法律界戮力同心，精诚合作，不断推动国际仲裁发展，为不稳定的世界经济增添稳定的力量，为全球治理做出积极的贡献。2020中国仲裁高峰论坛开幕式到此结束。下面进行议题研讨环节，有请世界贸易组织上诉机构前主席张月娇女士主持第一个议题。
Good morning, ladies and gentlemen. I'm very pleased to attend this very important conference on international arbitration. Particularly, I'm pleased to see so many old friends and close colleagues online and in the conference room present. I'm very honored to serve as a moderator for the first panel, which is very distinguished, of 4 outstanding professional women. The topic of our first session is leaders' vision on the challenges and the problems of international dispute settlement. I see that they are leaders in the field of international arbitration, either international investment or commercial arbitration. I think that you know all of them, so no need to make a lengthy introduction of their very distinguished career and remarkable contribution to international dispute resolution. First, I'm very honored to invite the Vice President of the World Bank Group and the Secretary General of the International Center for Settlement of Investment Disputes, ICSID, McNair. She has a very long career. Before serving the Secretary General, she was the Senior General Counsel of the Ministry of Justice in Canada. And currently, she oversees a group of 70 people, and they are handling more than 300 investment dispute cases per year. Very impressive. Now let us give a big applause to welcome Vice President, Secretary General McNair online.
Thank you. I'm so pleased to join you today and very sorry that I'm not there in person. I look forward to the time when we can see each other once again in person and that I can travel again to Beijing, which is one of my favorite cities that I've been to several times. We are especially pleased to co-host this conference with CTAC and the All China Lawyers Association. I'd like to move to the main topic, which is the question of new situations and challenges in international dispute resolution. And if I might say, Madam Zhang, it's lovely to see you again. And I'd like to share with the audience that, in fact, you have been one of the first arbitrators at ICSID doing a case through the remote system. So I think you will be both a moderator of this session, but as well a witness to how well the technology can be. I have a short presentation and I would like to share that with you, if I may, while I am speaking today. And if I can, I hope that you are able to see this well. So in terms of the first question about the impact of COVID, it obviously is in very early stages, and maybe it is too early for us to assess the impacts. But what I think is very clear is that the arbitration community has adapted relatively well to this situation. We had been using technology for some time at ICSID, but certainly in middle of March this year, when we all had to go home to work from home, we went to a very new level of full automation. At that point, I can remember the day we all left, we basically sent a note to all parties saying that from that point forward, every filing would be done through the internet and that all hearings would be done remotely and that decisions would be issued and rendered to the parties remotely. So it was a very big change and quite a sudden change. We recognize that some counsel might prefer to have in-person hearings in particular, but what became very clear was that this pandemic situation was going to last longer than anybody wanted, and so parties began to embrace the use of technology. We have had some very good results with our remote hearings, and I think you'll hear over and over again today that the consensus is this is very useful technology, it is very effective technology, and when used properly, it will save us all time and cost in a way we had not predicted before or not been able to do to date. It will avoid a lot of jet lag for many of our arbitrators and counsel, and it will help reduce carbon footprint. So it is very much a positive, if one can find positives, in what is a very difficult situation. Now, we have all learned a huge amount about how to do online hearings and how to do them effectively and smoothly. And our last session today is a small video that we have produced at ICSID to talk to some of the lessons learned. So I will not go into these in great detail, other than to say that I think the use of technology has been extremely successful. And my prediction would be that we are going to be able to reap the benefits of our increased ability and familiarity with this technology. In fact, what I think will probably be the next stage will be to see a lot more of what we are often calling hybrid hearings, where parties are essentially grouped in a location together. So today we have many parties, 10s, 20s, hundreds sometimes parties in different locations, I think the next step back will be parties together as a team in one location. So, for example, a council team in one location, arbitrators in another, and the other council team in a separate location. So we'll be seeing technology used in that fashion. And we will also be seeing continuous technological improvement. So that, I think, is what we can look forward to in terms of remote technology. And certainly our collaboration with other institutions has been very helpful, and we're all learning from one another. There is also another question or another issue in terms of COVID-19 and the impacts. And that is the question, perhaps, that you could call the substantive issue. Will there be new disputes that are based on measures governments have taken to address COVID? We have seen a lot of speculation and a lot of commentators saying that they think there will be new, what they're calling COVID cases. But I think it's important to remember at this point that we have not yet seen an international investment case arising out of a COVID measure. Now, this may not be a surprise because it usually takes a longer time for an international investment case to mature. But to date, we have not seen a huge number. In fact, we have not seen any so-called COVID cases. So I think that's important to remember. If we do see COVID cases in the future, would not be unlikely for them to be based obviously on contract and issues of force majeure where there was not performance of the contract. But we might also see them under treaty. And I think something that's very interesting is that in the last 10 years, we have seen a number of investment treaties addressing the question of whether a government is liable for taking measures to protect public health. And we have seen a number of very important cases where tribunals have looked at the impact of measures taken for the public good. And what has been made very clear by the tribunals is that government will be given a large degree of deference to protect public health so long as it acts in good faith and it acts on the basis of the facts and the evidence. So I think it's interesting that if COVID-19 cases do arise under treaty, we have a whole new era of jurisprudence, which has probably set the tone for how these will be addressed from a legal basis. Now, notwithstanding COVID-19, our efforts at ICSID have been to have business as usual, essentially, and to make things as smooth as possible for all parties. I think Mr. Lee correctly pointed out some of the challenges that we have seen in international trade and international investment dispute settlement recently. In terms of international investment dispute resolution, we certainly are in a period of reform and discussion, but I remain very, very optimistic about this. I see that in the last 10 years at ICSID, we have had 10 new member states join us. We have had a huge increase in the transparency of dispute settlement, and we have reform discussions that in many ways can be seen as a confirmation of the importance of international investment dispute resolution and the importance of an international rule of law so that we can go ahead and really have effective cross-border business. And of course, this will be more important than ever as we all try to recover from the adverse economic impacts of the pandemic. At ICSID, we've had a number of discussions about reform, and we are currently involved in the most comprehensive amendment process we have ever done. We had issued what we call working paper number 4 in February of 2020, and we were heading to an April 2020 consultation with our member states. And I think all of us felt that we were very close to finalizing the last few difficult items that were on the agenda. Now, unfortunately, that had to be postponed due to the pandemic. So we have asked states for further written comments, and we will be consulting our states very soon to make sure that we can maintain the momentum we had, even though it's very difficult at this point to have an in-person consultation. So while we might have been set back several months by the pandemic, we are certainly going full steam ahead, and we hope to be able to pull together a package for a vote for member states that will incorporate the amendments that have been addressed. In terms of the topics that we've been looking at, there are quite a few of them, but some of the key ones are, first of all, to address the time and cost of arbitration, which of course is an issue in both investment and commercial arbitration. We are doing this through a number of measures, including specific timeframes, a proposed expedited arbitration process, and several other mechanisms that all relate to increased case management. We see that case management has been very successful in domestic courts, and we are trying to bring more of that into the investment front. One of the most controversial topics has been the question of third-party funding, and we have proposed much more disclosure of third-party funding at the very early stages of the investment arbitration. So for the first time, we are proposing some regulation that addresses third-party funding. We have also addressed states' requests for security of costs and a more expansive test on security for costs. We are looking for even more transparency, in particular with respect to decisions, orders, and awards. And perhaps one of the things that may be most innovative and perhaps hold the most potential is some of the new mechanisms that have been proposed, in particular a set of standalone mediation rules that I think will be extremely important. And one of our big focuses is going to be to try and support parties who would like to mediate investor-state disputes. At the same time, we have been very involved in UNCITRAL Working Groups 2 and 3. Working Group 2, of course, working on expedited arbitration right now, and Working Group 3 working more on general reform to investor-state. And I know Anna Joubin-Brett will give you a more comprehensive view on this. And I think the only thing I would like to add at this point with respect to the working group number 3 is that one of the big items on its agenda is the question of a multilateral court, and in particular, an appellate body. And certainly ICSID has been active in this, and we hope that should states decide they would like an appellate body, that we can support it with the ICSID mechanisms, which are, of course, across the world. We have also done a draft code of conduct. And this, I think, is a very nice example of collaboration because the ICSID and UNCITRAL secretariats work together to put together a first draft of this code of conduct. And it is intended to apply to all investor-state dispute cases, regardless of the set of procedural rules that are being used. And you will not be surprised to know that we are dealing with a lot of very difficult issues, things like conflict of interest, double hatting, repeat appointment, and enforcement. And so this process has just started, but I think it is also one that holds a lot of support for the future of investor-state dispute settlement. So I will stop now. I think that should give you a quick overview of where we are in this era, but most importantly, where we are going in the post-pandemic era. And I look forward to seeing many of you in the near future, and I wish you a very good conference today. Thank you.
He has given us many very good news. First, until now, no case regarding COVID-19. I think one of the reasons, because the coronavirus is a part of, people cannot predict. So force majeure, it's not the liability of a particular country. I hope that they do not have that claim now, and they do not have the claim in the future. Second news, good news, is they have 10 new members join the ICSID. So congratulations, Meg. It's your contribution also to attract so many new members to join ICSID. And third good news is they are doing jointly with the UNCITRAL for the current reforms, particularly for ISDS reforms. It's very impressive regarding transparency, regarding the code of conduct. And I fully support the idea to set up a multilateral court for appeal. So I like the appellate body. So I hope that the appellate body for investment will be resumed. So congratulations to Meg, and thank you very much. Our next speaker is Lucy Reed. We all know her, and she joined the International Commercial Arbitration Chamber in New York early this year. But before, she worked for very long in Hong Kong and Singapore. She is currently the president of International Council for Commercial Arbitration, ICA. We all prepared to join their ICA annual meeting, unfortunately postponed. And she is also served as vice president of Singapore Commercial Arbitration Court. Now we give floor to Lucy. Welcome you, Lucy.
Thank you. Thank you, Madam Zhang, for the very nice introduction. Distinguished colleagues and friends like Meg, I wish I could be there with you in person, but we will do our best. I'm going to put up a few slides so that I can give you more information about ICA. Thank you. This should work. Very good. It's truly an honor for me to be here tonight on behalf of ICA. What I propose to do is explain how we at ICA are staying on course during the COVID-19 pandemic, which is what we think is most important for ICA. As a quick background for some of you who don't know ICA, it was founded in 1961 in the midst of the Cold War to promote the use of international dispute resolution across borders and legal cultures. The ICA Bureau is based in the Peace Palace, which you can see on the slide, and we work closely with the Permanent Court of Arbitration. But what's most important is for you to know is that ICA does not give any kind of institutional or administrative support to arbitration, unlike ICSID, for example. What ICA offers is knowledge, best practices, and networking through our congresses, our publications, and our projects. And our status as an NGO allows us to have neutrality and independence when so many nations come together to talk about arbitration and to tackle some of the hot issues that you've already heard about. Because knowledge is important, we're continuing on course through the pandemic with many new challenges, of course. We're a membership organization. We have over 1,000 members in 90 countries. You can see it on the map. And we have 7,000 members of what we call Young ICA. Young ICA has been set up to open the doors of international arbitration, commercial and investment, to practitioners under 40 through mentoring by arbitration leaders, through meetings and publications of their own. And Young ICA is operating very effectively remotely since last March. Now, I wish I could see you all. I can't see you all. But for those of you who are younger than, say, Meg Kinnear and I, we welcome you to Young ICA. You can sign up. It costs nothing. We would very much like to have you join our networking and contribute to the brainstorming that goes on with Young ICA. I think that during this pandemic, when people are so separated at home, the idea of groups of like-minded thinkers like Young ICA are particularly important. Now, when ICA was started way back in 1961, what ICA did was have biannual congresses starting in Paris in 1961. And each Congress has a theme, and there are usually two streams, one practice-oriented, one theory oriented. You can see from the slide, there have been other congresses in Beijing, in Rio, Singapore, Miami, Mauritius, Sydney, and as Madame Zhang mentioned, the next Congress is going to be in Edinburgh, we hope in February of 2021. We had to postpone it from last spring. The one after that will bring us back to Asia. It's scheduled for Hong Kong in 2023. And I think it's no exaggeration to say that the ICA Congress is the largest and the most anticipated conference on the international arbitration calendar. And for that reason, there was no question of canceling Edinburgh. The program is ready. We'll be going forward in February, we hope. The other thing that ICSID is known for is its publications. Again, Meg Kinnear has had a lot to do with this. Right now we have 5 main publications. They're all on kluwerarbitration.com. And I would submit that if you're participating in this summit, you know of ICA's publications. The first is the ICA yearbook, which is the orange volume in the center of your slide. This focuses on national court enforcement of arbitral awards. The yearbook has over 3,000 court decisions now on the New York Convention. Second, we have the ICA handbook, which is the 6-volume book that set of books that you can see in loose leaf format on the slide. The handbook has chapters on the arbitration law and practice of 80 jurisdictions that are prepared by experienced rapporteurs in each jurisdiction. The third main publication is the Congress series, which is a blue book on the right of the slide. This is a collection of edited papers from each Congress, and I know that one of the things I've been seeing on so many webinars in international arbitration is the collection of Congress books that are on the shelves behind the people speaking as sort of an indicator that they've been to our Congresses. Fourth and newer is the ICA report series, which are ad hoc reports on projects, which I'll come back to. And fifth but not least, and in fact maybe most important, is our guide for judges on the interpretation of the New York Convention, which is a practical overview of the convention for judges. Now, the last thing that we do is projects, very active projects. We've initiated collaborations, often through member task forces, on important issues in international arbitration. Just to mention a few: cybersecurity, third-party funding, issue conflicts in investor-state arbitration, data protection, and right now we're very close to finishing a project which is creating an electronic tool to systemize damage analysis and calculation in arbitrations, which works on algorithms. So whether it's an expropriation case or a commercial contract case, this tool will allow arbitrators and counsel to cut through to damage calculations. Now, our most recent work is, I think, most important for this summit. We're focusing on 2 front burner issues: diversity and the COVID-19 hearings. This year, a very active inclusiveness committee at ICA worked with the cross-institutional task force on gender diversity in arbitral appointments and proceedings, and published the report you can see on the slide, the yellow book on the slide. You can download this for free from the ICA website, and you will find up-to-date statistics, not all good, on the appointment of women arbitrators, and a robust discussion of opportunities to promote gender diversity in international dispute resolution and to start the discussion on other types of diversity. Most important for this summit in this world of virtual hearings and resistance by many parties to virtual hearings, ICA this very month has launched a comparative research project on questions relating to the right or not in international arbitration to a physical in-person hearing. And I stress physical in-person hearing because there is a discussion about whether an in-person hearing can be in-person online, which I think yes, or whether it has to be physically in person. There's a recent case in Switzerland, which I won't get into. It's obviously a question of national law. And what we're doing is publishing this report in the ICA report series under the title you can see on the slide. Does a right to a physical hearing exist in international arbitration? It's going to be in two parts. The first part, like our handbook, is a collection of snapshots, if you will, of the relevant law and practice in key jurisdictions, requirements for hearings connected to process and due process, of course. And the second part will be a collection of essays on jurisprudential themes, such as what about the party agreements to hold remote hearings? Do they stand up? How are the institutions interpreting their rules to allow virtual hearings? And of course, a look at due process. And the other things we can mention are the working groups that we have on Chinese arbitral practice, African arbitral practice, and the New York Convention. We're particularly proud of the ICA Tsinghua University Working Group, which published a compendium of Chinese commercial arbitration laws in ICSID reports. And absolutely central to ICA's work is judicial training on the interpretation and application of the New York Convention. What we do is run what we call roadshows, which are colloquia for national court judges and ICA members. You can see some of the cities that we've been to on the slides, and I will show you, more important than just the cities, here are some of the participants from ICA and national judiciaries. Looking forward, we're going to Edinburgh, as I said. This is the poster for Edinburgh, and which is our 25th Congress. The theme is the Age of Enlightenment with a question mark. So the Age of Enlightenment, question. And the reason for the question is the program committee thinks it's important to look at the successes of international arbitration as well as areas where we can improve. The program committee feels that maybe there are too many criticisms and we've lost sight of the improvements that have come in international commercial and investment arbitration over recent years. Some of the themes are, you can see on this slide. The ones I want to mention are use of new technologies and the impact of emerging global issues on international arbitration, including climate change, law of the sea, human rights, and pandemics. So to conclude, ICA is as active as ever. We're staying on course. We're doing more of what we do well through the pandemic for the benefit of our members and for the international arbitration community. And we really look forward to collaborating with more colleagues from China, from Asia, and from around the world, both virtually, in hybrid, and we hope soon in person again. Like Meg Kinnear, I wish you a very productive summit. Thank you.
For your updates, I think for ICA, 3 things to mention. I appreciate very much Lucian has mentioned the joint project between Tsinghua and the ICA. In fact, the China's Supreme People's Court has been also working for this project. The publications is very useful for all arbitrators training. And also, particularly the current issues, the virtual hearings, the right compared to the physical hearings, those latest development we need to follow. And the young ICA, very impressive. The Tsinghua has held also Young ICA conference. We are going to continue to cooperate with the ICA. At this stage, I would like to propose next ICA or next ICA conference, maybe held in Beijing. So do you agree? So, because we have so many arbitrators, the International Council for Arbitration, Commercial Arbitration, should be held in Beijing. Thank you. Now our next speaker as very impressive, outstanding lady at the United Nations UNCITRAL, the Secretary of the Commercial Law Commission, Anna Brett. She has a very distinguished career. Before joining UNCITRAL, she served as a senior advisor to UNCTAD in Geneva. And also she has received a law degree from France, from the US. If we look at her work, very impressive. New York Convention, the Singapore Convention on mediation, and currently Group 2, Group 3 for investment reform. Very, very important. Now we will welcome Anna Brett, Secretary of UNCITRAL, to give us updates for the leader's vision. Thank you. Can you hear Anna?
Good morning from Vienna and ni hao to all of you attending the China Arbitration Summit 2020, wherever you may be. I'm confident that the hosts of this year's summit, CTAC and ICSID, along with all China Lawyers Association, have made great efforts to transforming this annual event into a virtual one, as we have all been doing in UNCITRAL, the United Nations Commission on International Trade Law, as well, over the last couple of months. It gives me great pleasure to address you, be it remotely, on this panel entitled New Situations and New Challenges in International Dispute Resolution, along with my close friend Meg Kinnear and Gabriele Kaufmann-Köhler. The organizers of this panel have asked us questions following closely on the topics of the UNCITRAL Commission session during a virtual panel series in July of this year on COVID-19 response and recovery, where the relevance of UNCITRAL texts as tools to assist states and operators of international trade were discussed. You will agree with me that COVID-19 has caused an acute health, economic, and social crisis worldwide. The severe economic fallout from the pandemic is unprecedented, with micro, small, and medium-sized enterprises being hardest hit. While the COVID-19 crisis will likely continue to disrupt international trade and economic activity in the foreseeable future, a strong legal framework will assist to preserve, protect, and revitalize commercial activity and global trade. That is why the role of UNCITRAL is so significant and why our member states have emphasized it strongly. To assess the challenges brought about by the pandemic and to explore how the legislative tools of UNCITRAL can mitigate these effects, the Commission, as I mentioned, held a series of virtual panels during the first part of its 53rd Commission session in July 2020. Each of these panels dealing with thematic aspects of UNCITRAL's work that could assist COVID-19 recovery efforts by states. Leading experts for multinational corporations, international organizations, development banks, agencies, and think tanks, joint government representatives from diverse legal systems and different levels of development in the discussions. A number of Chinese experts and academics took part in those panels, including Secretary General of CETA, Mr. Shengjie Wang, my good friend. This webinar series resulted in an incredible turnout with an average of 1,300 registrations for each virtual panel. Now, please allow me to first give you an overview of the issues discussed during this panel, as I have been asked to do by the organizers. The first panel discussed issues relating to identification and authentication in the digital economy. The COVID-19 crisis has highlighted the need to manage risks associated with human interaction, thus providing an additional impetus for businesses and governments to accelerate the transition to online transactions. But when you move online, you need to have additional assurance that the person or the company you're engaging with is actually what it claims to be or who it claims to be. Thus, priorities in digital identification have come to the forefront. And although the ways of identifying and of digitally identifying vary from region to region, the panel demonstrated that government and businesses around the world share a common interest in enhancing security and trust in online services through mutual recognition of systems that identify and confirm the identity in an environment of trust. Panelists of this first virtual panel acknowledged that laws recognizing the use of electronic signature have been in place in many jurisdictions for several decades, including those based on the ancestral texts. Despite the enabling effect of these laws, it was noted that there was need to educate users on their application. The panel discussed the benefits of a technology-neutral approach, the interoperability of identity management systems, and the portability of identity credentials across systems. The best example I can think of is in the area of international arbitration. And I'm glad to have my friend Meg Kinnear, SG of ICSID, virtually sitting next to me. Arbitral awards still require the original signature of 3 arbitrators that have not been able to travel to deliberate and sign together. So what works for traders concluding contracts should also work for an arbitral award, especially when it is authenticated by an institution such as ICSID or CTAC. And it was further observed that the advancement of digital signature services will facilitate continuity of economic activity and enhance quality of life, especially during a pandemic, and common authentication standards would facilitate identity management recognition across legal systems. The discussion on the second day was focused on digital economy and trade finance. The discussions relating to the digital economy continued during the second day, where the disadvantages of traditional paper-based practices in trade finance and logistics were brought into focus. While many banks remain reliant on paper documents, the pandemic has highlighted the urgent need for fully digitizing business processes to mitigate risks related to human interaction, to reduce costs, and to improve overall credibility and governance. Day 2 panel, hosted in partnership with the International Chamber of Commerce, thus focused on the digital economy, trade finance, and the associated needs for legal reform in a very traditional field that has long been adverse to technological changes. The panel made an urgent call for more resilient supply chains and global coordination in the digitization, modernization, and legal harmonization of trade finance and logistics. In particular, reference was made to increased data sharing, the application of blockchain technology, and the digitization of cross-border electronic services as a possibility for mitigating delays in the processing of trade finance instruments. Emphasis was also put on the modernization and harmonization of the legal ecosystems for payment. As the global trend towards a reduction in the use of cash, it was observed that agile governance and global collaboration could expedite the development of an efficient legal framework for global payments. Day 3 focused on assisting economic recovery for MSMEs. The third panel, hosted in partnership with the World Bank Group, focused on assisting economic recovery for MSMEs. MSMEs globally account for 2/3 of private sector jobs and 40% of GDP. However, lockdowns and other COVID-19 measures have disrupted severely their operation. They also bear a disproportionate burden of regulatory measures and face obstacles to access essential credit and efficient insolvency proceedings. Despite temporary relief measures, insolvencies of MSMEs have begun to rise dramatically, and thus the panel explored the importance of simplified insolvency proceedings for MSMEs, the work currently underway in UNCITRAL's Working Group 1, building on UNCITRAL's insolvency framework. The panel also considered the measures to enhance MSMEs' access to credit, as lack of revenue during the COVID-19 lockdown has increased MSME dependency on credit from financial institutions. UNCITRAL texts in both areas, insolvency and secure transactions, were highlighted and will hopefully assist in recovery. Day 4 looked at 2 areas of government contracting, namely public-private partnerships, also known as PPPs, and public procurement. In view of the sudden and urgent need for medical equipment and services, which far exceeded the usual demand, and the continuing need for normal government operation to procure the goods and services necessary to deliver services to citizens, public procurement has been a key issue in the COVID-19 context. The panel on public procurement discussed recent trends toward convergence in legal rules, including the possibility of enhancing the work of public procurement through platforms. The PPP panel discussion focused on force majeure, noting the increased cost of performance for PPP contracts resulting from suspension of performance, health requirement expenses, and price surge due to shortfalls in supplies. In day 6, we moved a little bit aside from the usual focus in UNCITRAL. We looked into gender, trade, and COVID-19. Emerging data shows that women are bearing a disproportionate burden of the economic fallout from the COVID-19 crisis. This is mainly due to their greater economic activity in sectors, including informal sectors of the economy, that have been hardest hit by the crisis. Coupled with an increase in unpaid care work, women are now earning less and saving less. The virtual panel on the last day, organized in collaboration with UN Women, highlighted how UNCITRAL texts could help promote pro-women and gender-responsive policies in a post-COVID-19 environment. This would be in line with the Sustainable Development Goals, particularly the support for many MSMEs that are owned or co-owned by women. The panel explored the potential of mediation as a flexible and informal dispute resolution tool that could be particularly suited to women entrepreneurs. The panel also focused on the adoption of simplified business registration systems as a means to encourage women entrepreneurship in developing countries. Now, having gone through, with this summary, through 5 out of the 6 panels that took place during the Commission, I'd like to draw your attention now to day 5, which was the panel co-hosted by Vienna International Arbitration Center, which addressed the same topic as today's panel, namely the impact of COVID-19 on international dispute resolution. As you know, CTAC was one of the institutions that issued a joint statement in May 2020, encouraging parties and arbitrators to mitigate the effects of any impediments caused by the COVID-19 pandemic, while ensuring the fairness and efficiency of arbitral proceedings. The statement also called for collaboration among institutions, making use of digital technology in resolving disputes remotely. Accordingly, several arbitral institutions have adopted responsive measures and have issued guidelines to assist parties and arbitral tribunals. The first session of this panel looked at immediate measures that were taken by arbitral institutions from across the world, including CTAC, as I mentioned, to respond to the COVID-19 crisis. Digital technology is being increasingly used to facilitate the conduct of arbitral proceedings, including online case filing and management tools, virtual hearings, and digital authentication processes for the rendering of awards. While virtual hearings are not new per se, the pandemic has caused its use to proliferate, and there are discussions within Working Group 2 to facilitate the use of remote hearings. and I'm sure that my co-panelists and friends here will be able to illustrate this approach much better than me. The second session, however, and I would like to focus a bit more on this aspect, looked at how international dispute resolution would likely evolve as a result of COVID-19 in the long run, noting that the crisis had already accelerated changes that would have taken years to develop otherwise. Panelists discussed a variety of innovative measures such as increased digitization and further use of technology, expedited procedures, the use of artificial intelligence, asynchronous hearings and online platforms, which could reshape the future of the international dispute resolution landscape. It was suggested that the emergence of digital tools such as AI in arbitrations could also lead to changes in the legal profession, as well as the training for future arbitrators and counsel. And what we need to look at is the long-term impact of such changes. While the crisis has accelerated changes that would have taken otherwise years to develop, we are likely to witness a variety of innovative measures in dispute management. And these expedited procedures and the adaptation of international dispute settlement methods will be most needed in the development or to accompany the development of the digital economy, where it can simply not be envisaged to await 3 months or even 3 years for a decision to be made. The use of artificial intelligence will therefore change considerably, and I'm convinced of it, the legal landscape. And while I'm not sure that we are yet at the point of having Cortana, Siri, or even Alexa settle our commercial disputes, I think that simplification and relaxation of formal processes to enhance expediency of the arbitration process would likely become the norm. However, despite all possible future developments, panelists insisted that the fundamental principles of fairness, access to justice, and due process need to be preserved. In that context, experts recognized that UNCITRAL's texts on dispute resolution were flexible enough to adapt to and to accommodate changing circumstances, but also welcomed an examination of these texts in the context of the evolving environment. And this brings me to the point of the current work of UNCITRAL in the field of dispute resolution, yet leaving aside the reform of investor-state dispute settlement, whereby Working Group 3 is steadily making progress with a number of reform options, including a code of conduct developed jointly with ICSID, an advisory center, third-party funding, as well as with respect to the selection and appointment of adjudicators. Working Group 2 is continuing its work to prepare rules on expedited arbitration, a more streamlined and simplified procedure with a shortened time frame, making it possible to reach a final resolution of the dispute in a cost and time-effective manner. When you're seeing this video, the working group will have begun its first hybrid session to conduct the second reading of the expedited arbitration provisions, which would likely accompany the UNCITRAL arbitration rules. There are also other topics in the area of dispute resolution that are on the horizon. I'm recording this video on the 10th of September here in Vienna to meet the deadline set by the organizers to send the video. So unfortunately, I cannot report yet to you the results of the deliberation during the commission session, which will take place only next week. I can only speculate that the commission will authorize the Secretariat to continue preparatory work on the following topics. First is online dispute resolution mechanisms, in other words, the use of AI, an automated system to handle complaints and resolve disputes, including through the use of a mechanism mandated by an online platform or inbuilt in an online platform. This will likely supplement previous work undertaken by UNCITRAL, which resulted in the technical notes on ODR. Second is work relating to disputes arising out of transactions in the digital economy, including within the high-tech industry or within this digitally leading industry. I'm hesitant to call them unicorns. The need for work in this field was brought to the attention of the Commission last year by the government of Israel and Japan, and it's likely that the topic will remain on the agenda of the Commission. And in addition, the Commission is meant to look into a proposal by Belgium to consider revising the ancestral arbitration rules more generally to address the impact of COVID-19, a proposal from Japan for the Secretariat to take stock of the pertinent developments in the field of dispute resolution in the current times, and a proposal from Russia to tackle the consequences of COVID-19 on a number of different areas of international trade law. The deliberations of the Commission next week will guide our preparatory work to be undertaken and possibly also for working groups in the coming months. In summary, I'm proud to report to you that Ancestral is actively preparing itself to address the unprecedented situation that we all face, as well as the evolutions that are expected in the field of dispute resolution. I'm quite confident that we will be able to overcome the challenges that we were facing so that the framework for international dispute resolution, be it mediation or arbitration, achieves the result that the parties are seeking, a fair and efficient resolution of the dispute. This would allow them to continue to operate their businesses even with the challenges they face due to COVID-19. And as a word of conclusion, a resounding and powerful theme from all of the Ancestral virtual panels was that the world cannot afford to wait any longer to build back, whether it be the digitalization of trade finance, vital to economic recovery, simplification of business registration and building, assistance procedures for MSMEs, the establishment of standardized digital procurement tools and practices for emergency contracting, enhancing access to justice while ensuring fairness, efficiency, and due process, or the empowerment of women as entrepreneurs, legal practitioners, and policymakers at the forefront of the COVID-19 crisis. Thank you very much for your attention. And let me end here by citing the United Nations Secretary General Antonio Guterres, who stated that COVID-19 is a human tragedy, but it has also created a generational opportunity, an opportunity to build back a more equal and sustainable world. Thank you very much.
Well, very much.
Mr. Yang Wang Ming.
Secretary of Ancestral. She gave us a very comprehensive and informative of updates of Ancestral dealing with the difficulties facing and caused by COVID-19. Particularly, she mentioned widely used digital technology, digital signature and virtual hearings, and the simplified procedure of insolvency procedure to facilitate the MMEs, the SMEs. So I think it's very useful, and also regulations on the PPT and the public procurement for medical supplies. And their work jointly with ICSID on the code of conduct has a significance for all of the arbitrators that we are here. And particularly she mentioned the gender issue. I'm very happy. The gender equality is no problem. Look at our panel. All four outstanding speakers, they are professional women. Our next speaker also a distinguished Chinese woman, and Dr. Shen Hongyu, and the Deputy Chief Judge at the People's Supreme Court, and she is deeply involved in the setting up of International Commercial Court, and she has handling many commercial and maritime cases. And now I give floor to Dr. Shen Hongyu. Thank you.
Good morning, ladies and gentlemen. Thank you for having me, Honorable Judge Zhang, and Secretary Mag, Secretary Anna, and Professor Lucy Reed. So it is my great privilege and honor to working with such a highly valued and knowledgeable panelists. Today, I'd like to introduce you the CICC, China International Commercial Court. I will introduce 5 features of the CICC. The first feature that makes the CICC so unique is that it is a part of a Supreme People's Court, the highest court of China. The CICC operates as 2 special divisions of the SPC. So the first CICC is situated in Shenzhen, and the second CICC is situated in Xi'an. As the CICC is part of the SPC, the decision of the CICC is a decision from the SPC. So the decision is final, conclusive, and enforceable at the first instance, not subject to appeal. So it is different with the municipal courts, where the cases are usually tried by the district court or intermediate court and then appeal to the higher court for the second and final instance. My foreign colleagues may wonder if litigants of the CICC have the remedies if the CICC decision is wrong. Yes, there is an error correction procedure. According to Chinese civil procedure law, the applicant of the CICC decisions have the right to apply for special review, namely the retrial application. And the application goes to the 4th Civil Division of the SPC. And the review grounds include manifest error in law, lack of evidence to support the fundamental facts, violation of due process, and etc. So up to now, the CICC merely accept 14 cases and conclude 5. So we still need to learn experience from the other international commercial courts. The second unique feature is the creation of the International Commercial Expert Committee. The Judge Zhang is our honored member. The 31 eminent jurists, retired judges, and lawyers from 14 jurisdictions became the first group of members. They play a key role in solving disputes. Entrusted by the CICC, the member act as the friends of the court with 4 functions. First is to mediate international commercial cases. Second, provide expert opinions on international treaties, commercial rules, and foreign law. Third, give advice on the SPC judicial interpretations and policies. And the last one is to give advice on the development of CICC. So currently, we are expanding the committee and inviting the second group of expert members. The third feature is while proceedings in the CICC are governed by Chinese civil procedure law, CICC judicial interpretation and procedural rules provide some procedural innovations regarding jurisdiction, evidence, determination of foreign law, and so on. About the jurisdiction, the CICC hears a case with international commercial nature. If one or both parties are the foreign parties or the subject matter located outside of China, or the legal facts that create, alter or terminate the legal relationship takes place outside China, then the case has an international nature. The CICC has jurisdictions mainly based on the parties' consent, and also the jurisdiction over the case transferred from the High Court and the case related arbitration at the one-stop platform. I will talk about this later, at the discretionary jurisdiction of the SPC. So if parties have submitted to the CICC jurisdiction by agreement, then the case dispute amount shall exceed 300 million RMB. That is approximately $40 million. So about the evidence, no mandatory legalization is required for foreign evidence before the CICC. And also the Chinese translation of evidence in English is not compulsory with the consent of parties. Although China is not a member of the Hague Apostille Convention 1961, the CICC is dedicated to simplify the certification requirement in order to make a procedure more faster and more cost-effective. Actually, it is very interesting that the CICC innovation on foreign evidence pushed the reform of the Chinese civil evidence rule. Last year, the SPC issued the evidence judicial interpretation and the legalization of the foreign private documents were abolished. So only keeping the public documents from foreign countries to require the legalization requirement. About the findings of foreign law, unlike a common law jurisdiction, foreign law in Chinese civil litigation is considered as an issue of law, apart from traditional finding approach, including judicial assistance, the statement from the embassies, and also the expert opinions. The CICC accepts opinions from the foreign law ascertainment agencies and the international commercial expert members. Judge can also find foreign law by his or her own initiative through the reasonable methods such as the internet database like this, Westlaw, etc. So during the pandemic, as the issue of a force majeure became focal point of the finding of foreign law, CICC delegated our agencies and committee members to summarize legal provisions and the cases on force majeure from 60 jurisdictions. So these reports were published on the CICC website and welcome to visit it. Foreign legislations, as well as the cases and the expert evidence on foreign law, shall be cross-examined by the parties. The SPC is currently working with the memorandum with the Singapore Supreme Court on mutual assistance in determining the foreign law. CICC also hybrids other common law features like allowing dissenting opinion being stated in the judgment. So the fourth salient feature of the CICC is, namely, the one-stop dispute resolution platform. The CICC set up a platform incorporating the first group of 7 arbitration and mediation institutions, including CITAC, SHAC, Beijing Arbitration Center, Shenzhen International Arbitration Center, China Maritime Arbitration Center, and so on. The idea is that the parties are free to choose their preferred mode of dispute resolution within the platform, and the CICC facilitates their chosen mode with enforceability according to corresponding procedures. If parties reach a settlement agreement resulting from mediation, the CICC may convert the agreement into a judgment or a conciliation statement with the equivalent effect of a judgment upon parties' request. If parties choose arbitration and also the dispute amount exceeds 300 million RMB, the parties can apply to the CICC for interim measures, setting aside or enforcement of the award. But unlike the IFCC, CICC's judgment cannot be converted into an arbitral award. China is signatory to the Ancestral Mediation Convention, Singapore Mediation Convention, yet to be ratified by the National People's Congress. So we look forward to the litigation, mediation, and arbitration will play more complementary role to enhance the dispute resolution efficiency after China's ratification. The electronic one-stop platform of the CICC is under construction, and we expect in future it will not only connect litigations, arbitration, and mediation online, but also incorporate more facilities, including filings, evidence exchange, court hearing, determination of a foreign law, and interpretations, etc. Availability of an increased convenient option in resolving disputes will be more beneficial to the whole international commercial community. The last feature I want to emphasize on is the increased use of technology. On the 4th September last year, the SPC issued a white paper titled Chinese Courts and Internet Judiciary. You may gain a better understanding of how Chinese courts are applying technologies in the Smart Court project after reading that white paper. For judicial openness, it is notable that as of 30 August this year, over 100 million judgments are freely available on the website of China Judgment Online, with a total of 48 billion visits. Regarding judicial transparency, all SPC's public hearings are required to release online, except stipulated otherwise by law, such as the case concerning business secrets, etc. And more local courts are also joining the China court hearing online. The CICC has its own bilingual website, cicc.gov.cn, and 5 decisions were already released on that website. So lastly, as to the COVID-19 pandemic's impact on litigation, I'd like to share my own examples. I personally have the unpleasant and unpleasant experience on the virtual hearing. The first case I heard a court hearing online was a patent case heard via an app, namely mobile phone court. So my mobile phone screen is so small that each party occupied merely a tiny window. Connection was unstable, background noises from those parties interrupted hearing for several times. However, to my surprise, all parties showed their greatest patience, and later they reached a settlement agreement. So this case gave me a new perspective about the judicial behavior. Between the COVID-19 healthcare crisis, trade war, and the interrupted global supply chain, there are the other side of the story. People become more cooperative and emphatic during the pandemic, and the challenges and issues are addressed each one by one, and the things are often better than current media would like us to think. And now the app, the mobile phone court app, was replaced by a more sophisticated and well-developed online hearing system. And more litigants get used to the time-saving and cost-effective online hearing. There were still litigants resisting the virtual hearing, so they prefer to physical appearance before the court. So my lesson is to contact the litigants as early as possible and to get their consent. As Chief Justice Zhou Qiang said at a symposium of the Justice meeting on September 2, the mission of Chinese courts during the pandemic and post-pandemic era is to secure trial and judgment enforcement without interruption and to achieve continuous, timely fairness and justice. Today's technology offers us the best platform to exchange and collaboration beyond the borders. So let's embrace the uncertainties, make joint efforts, and try our best to accommodate the needs of the parties for fair, efficient, and cost-effective dispute resolution, and to guarantee the rule of law. That's the path forward for CICC in a changing world. So I will stop here and thank you very much, and I will look forward to meeting you in person in the near future.
Thank you very much, Dr. Shen Hongyu of the SPC Supreme People's Court. I see that we have exceeded the time limit. I have no time to make a conclusion. We all agree that the first panel with the leader's vision, they all share and provide very rich and also very thoughtful visions and their current practices. They are all working very hard, non-stop, despite the COVID-19 pandemic. But they are still working through digital technology and through also the preparation of joint programs and further push forward international investment dispute reform. So let us give them, the panelists, outstanding speakers, a big applause and our thanks. I hope that they can hear, and the next time we can see all of them in person. Now I switch the role of moderator to my successor, Professor Shan Hua, and Dean of the School of Law of University of Jiaotong at Xi'an Jiaotong University. Thank you. I give you the floor.
Distinguished guests, including obviously the online guests, ladies and gentlemen, it's a tremendous honor to moderate this formidable panel on a very important topic: institutions' efforts on Belt and Road international arbitration cooperation and responses to the COVID-19. Obviously, the COVID-19 has changed fundamentally the life and work of the world today. And today, we are here to have the meeting. In the previous session and our session as well, we will see a combination of three formats of presentations: on-site, online, with video presentation, and also online presentations. This is the difference. International arbitration is one of the, if not the, most affected area of legal businesses because of the international nature. Today, we have a panel of 6 speakers coming from Asia, Africa, America, and Europe, including, or not, UK. They all have a very distinguished career, a very lengthy CV, but we have 8 of them, so I would try to be short in introducing them. Another very significant feature of this panel is that it has 7 men and 1 woman. I was very embarrassed to find out whether that would be a gender issue, as mentioned by Justice Zhang Yejiao. But I was very comfortable now after a session full of women in the previous session. So I think it's a healthy sort of a neutralization of this conference. Our first speaker is Secretary General Wang Chengjie. He's also the Vice President of CIATEC. Mr. Wang Chengjie is the host, the major host of this conference. Obviously, the conference is also hosted by ICSID and by All China Lawyers Association. I happen to be a member of all the 3 as an arbitrator of CIATEC and conciliator of ICSID and a lawyer member of the Lawyers Association. Mr. Wang Chengjie is certainly a most experienced arbitrator and arbitration leader in China and worldwide. I think he does not require any further introduction. Let's warmly welcome him to give his speech on site.
尊敬的各位嘉宾、女士们、先生们，大家上午好！很高兴呢，有机会与海内外的新老朋友们，在中国仲裁高峰论坛再次相聚。2020年新冠疫情全球蔓延，给国际仲裁带来了严峻挑战。本届论坛聚焦疫情下争议解决的革新与发展这一主题，分享应对疫情的有效措施或经验，我认为是非常的有意义。作为主办方，也感到很高兴能搭建这个平台。与许多国内外的仲裁机构一样，贸仲在疫情期间积极应对，为推动仲裁程序正常高效运行，采取了一系列的有效的措施。借此机会我想跟大家分享一下，我认为是经过实践、检验、及时而富有成效的几项措施。一是关于网上立案，借助贸仲2019年研发的在线立案系统，早在今年的1月底，也就是疫情爆发的初期，贸仲就及时发布了疫情应对的紧急通知，建议当事人通过网上立案的方式提交申请材料。网上立案系统采取无接触式立案，同时满足了实时的咨询、身份识别、线上提交材料等需要，解决了疫情中的立案难题。统计数据表明，截至2020年8月31日，当事人通过贸仲在线立案系统共计完成立案是554件，比2019年在线立案同期增长了2.9倍。而且从我们的现在接触来看，在线立案已经成为当事人向贸仲提交仲裁申请的重要的渠道。在线立案系统的运行，也使得贸仲的立案数量并未受到疫情的严重影响。截止到2020年8月31日，贸仲年度受理案件数量是2235件，同比增长6.78%。其中涉案案件在去年大幅度增长的基础上，今年又增长了16.6%。案件当事人涉及66个国家和地区，我想这跟我们的在线立案还是非常有关系的。我要介绍的第二个方面措施是关于推进仲裁程序的问题。贸仲于2020年4月率先发布了关于新冠肺炎疫情期间积极稳妥推进仲裁程序指引。指引明确指出，仲裁庭已然负有公正高效推进仲裁程序的责任，当事人已然负有诚实守信参与仲裁程序的义务。针对受疫情影响仲裁程序进行的相关问题，我们倡导综合运用在线立案、电子送达、书面审理、在线庭审、在线调解、部分裁决等多种程序措施，为疫情下当事人和仲裁庭如何高效进行程序提供具体建议。此外，贸仲还采取仲裁员电子签名、电子印章等技术手段，最大限度地减少疫情影响，积极稳妥推进仲裁程序。今年1到8月，贸仲已审结案件1597件，其中以书面审理方式审结和当事人自行和解或调解结案的案件比往年大幅增长。我要介绍的第3方面措施是关于线上开庭。贸仲程序指引明确规定，在线开庭是一种具体的开庭方式，符合贸仲仲裁规则关于仲裁庭可以按照其认为适当的方式审理案件的规定。但同时，我们指引也规定，仲裁庭决定在线开庭，应综合考虑双方当事人的意思、案件复杂程度、证人出庭等因素， 应当充分保证当事人的程序权利，给予双方当事人陈述和辩论的合理机会，确保平等对待双方当事人，确保仲裁裁决根据所适用的程序法具有可执行性。贸仲于今年4月专门开发了智慧庭审平台，并专门发布了视频庭审规范，解决了大家比较关注的线上庭审的有关程序和技术问题，包括仲裁参与人身份识别、证据电子化提交、线上同步笔录、扫码电子签名、仲裁庭合议、背对背调解等等。视听资料、电子数据等证据可以在贸仲智慧庭审平台上便捷地实时展示。在这些程序规范和技术的保障下，各庭审参与方足不出户就能参加线上开庭，既避免了疫情期间人员聚集的风险，又大大节约了时间和费用，有效推进了程序的进行。截止目前，贸仲智慧庭审平台已在线开庭165件，来自美国、加拿大、澳大利亚、瑞典、中国香港及内地的近40个城市的仲裁参与人参加了线上庭审。线上开庭已逐步被仲裁庭和当事人接受。我要介绍的第4方面措施是多元化庭审模式，有效满足了不同类型案件的庭审需求。疫情期间，贸仲开展了多元化庭审模式的认真探索。一方面，对于事实清楚、证据材料简单的案件，建议在仲裁规则允许范围内采取书面审理的方式。另一方面，基于疫情期间对于在线庭审服务的大量需求，利用贸仲在线庭审平台以及给予贸仲在全球派出机构与合作机构众多、总峰会一体化的独特优势。目前贸仲在境内外共有17个分支机构，并与70多个国际争议解决机构签有合作协议，大家相互提供庭审设施使用以及其他的庭审服务合作。我们充分利用现有的这些线上和线下资源，实现不同法律、时区、地点的人员可以实时同步无迟延的连接以参与庭审。经过一段时间的经验积累，我们最终探索出包括线上、线下、线上与线下相结合的多元化庭审模式，足以满足不同案件复杂的乃至个性化的庭审需求。2020年6月4日，贸仲香港仲裁中心受理的一起仲裁地在香港的国际仲裁案件，就是采用了线上与线下相结合的方式，成功实现了2州、2国、4城市之间的同步开庭审理。实务中诸多的案件对此均有展现，因时间关系问题不一一介绍。除此之外，为应对疫情及后疫情时代仲裁的发展，我们将进一步提升信息化办案系统建设，这包括今天各位国际上的这些专家所介绍的相关情况、信息化建设情况。我们要打通仲裁庭、当事人和仲裁机构等多方立体网络案件审理的高速公路，全面推动网络仲裁服务，为中外当事人提供更为便捷高效的仲裁法律服务。各位同仁、各位朋友，2020年疫情在全球蔓延，国际仲裁面临巨大危机和挑战，也得以焕发更多潜力和生机。我们深刻地认识到，在这场危机应对中，仲裁程序的灵活性、保密性、程序正当性和当事人意思自治原则应得到更为深入的思考与践行。这场灾难会更加凸显出国际仲裁界加强团结协作的必要性和重要性。2019年，贸仲与国内外40余家争议解决机构共同发布了《北京联合宣言》，倡议加强国际合作，共同推动多元化争议解决机制在全球范围推广。我们还将继续努力推进更为清晰、具体的合作安排，让北京联合宣言所倡议的理念行稳致远，为应对疫情下国际仲裁的发展做出积极的贡献。最后，感谢各位的耐心聆听，祝大家 参会愉快。
Thank you, Secretary General Wang Chengjie. It is undoubted that CEATEC has done tremendously well in coping with COVID-19, with a 16% of increase in international cases, and a smart arbitration platform together with diversified methods of hearing. But I'm also equally impressed by the persistent commitment to international cooperation, particularly in the context of the Belt and Road construction. Our next speaker is ICC, the chairman of the ICC Court of Arbitration, who is Alexis Moore. He will join us online, well, not online, by video presentation. Let's welcome him.
Dear Mr. Yan Wanming, Vice President of the Supreme People's Court, dear Mr. Li Shengan, Assistant Minister of Commerce, dear Ms. Gao Yan, Chair of CCPIT, dear Mr. Lu Pengqi, Vice Chairman of CCPIT, dear friends and colleagues, I would like to thank the organizers of the China Arbitration Summit 2020 for inviting me to deliver this speech in occasion of this important conference, which, due to the time difference with Europe, has to be recorded. I am deeply sorry for being unable, due to COVID, to be physically present in China in this occasion, and hope to have soon the opportunity to meet all of you personally again in your great country. COVID has already deeply changed the practice of international arbitration for parties and for institutions. To the ICC, it has been a particularly difficult challenge. The ICC organizes, on average, every year, about 150 court sessions in multiple locations on the globe, in the occasion of which more than 500 awards are scrutinized and thousands of decisions are made. Each of these court sessions involve from 3 to 50 court members, depending on the format, committees, special committees, or plenaries. The court has been able to completely reorganize its internal work so as to allow all members of the Secretariat to work remotely and all court sessions to take place by video conference. So that, in spite of the pandemic, the work of the court has proceeded without added delays to the parties. Equally, our training activities, which are so important to the development of future generations of arbitrators, have continued online in all continents. We are nonetheless acutely aware that in many emerging countries, the personal contact and exchange is extremely important to the development and training of new generations of arbitrators, and we will need to resume our personal presence as soon as COVID will permit. COVID has presented even greater challenges to arbitrators and parties. All players are becoming more and more familiar with the technology, and technology will continue to improve so that even long and complex evidentiary hearings can now be organized remotely in a stable and secure manner, essentially under 3 conditions. The first is that the tribunal engages as early as possible in consultations with the parties as to the need and appropriateness of holding the hearing remotely. The second is the selection of a state-of-the-art platform, allowing the necessary functionalities such as manipulation of documents or conferences between the arbitrators, as well as technical support and the organization of testing before the hearing. And the third is the establishment of an appropriate cyber protocol, recording the agreement reached between the parties and the tribunal for the organization of the hearing. The ICC is also providing technical support to the parties, and the ICC Hearing Center can assist in the organization of virtual hearings. The ICC Court will soon offer a new platform allowing parties to upload and manage their submissions and exhibits online. The ICC, finally, has provided guidance to parties and tribunals in its COVID-19 practice note, which has been issued in March of this year, including a model cyber protocol that has been very well received by the arbitration community. The ICC COVID-19 practice note encourages parties and tribunals to discuss and implement measures aimed at mitigating the delays that may be generated by hearing postponements due to COVID-19. Virtual hearings are uncontroversial as far as case management conferences are concerned. They are also widely accepted in the context of urgent proceedings such as emergency arbitration under the ICC rules or proceedings related to dispositive motions. For large and complex evidentiary hearings, however, the organization of a hearing by video conference requires extra care, consideration of all relevant circumstances, and a careful consultation with the parties, in particular when one of the parties objects. While a party should not be entitled to delay the outcome of the arbitration by objecting to the organization of an evidentiary hearing virtually, a virtual hearing should not be organized for the convenience of the tribunal or result in a significant disadvantage for one of the parties. There is no way back. Technology will remain a fundamental aspect of the efficient conduct of any arbitration. And as technology improves, it will more and more be so. Holding a hearing online should no longer be considered as an exception or a departure from normal procedures. It will more and more be considered on the same footing as a physical hearing and will become an item in the agenda of any case management conference. In the post-COVID world, arbitration will move decisively away from its current pervasive culture of paper. Becoming greener is another way for arbitration to contribute to a better future for the world. The ICC is fully committed to that goal. Thank you very much for your attention, and I wish you a fruitful and successful conference.
Thank you, President Moore, for the presentation. President Moore is actually has actually worked in many arbitration institutions, and he has also personally handled over 260 cases himself, being obviously a remarkable leading arbitrator. And his presentation summarized the experiences of ICC in dealing with COVID-19. And obviously, it's equally impressive is its commitment to provide public service to the global arbitration community, including training. I think the three conditions that he summarized on online hearing is very precise. Let's thank him once again for his presentation. Our next speaker is Rinsky Yuan, who is the co-chair of Hong Kong International Arbitration Center. As many of you have known, that he was the Secretary of Justice in the Hong Kong government for a number of years. Let's welcome him to provide a video presentation. Welcome.
Secretary General Mr. Wang, fellow members of the arbitration community, ladies and gentlemen, first of all, may I express my gratitude for inviting me to join this year's China Arbitration Summit. I can still vividly recall what happened during the China Arbitration Summit last year. This year, it is regrettable that I cannot join in person. Nevertheless, it remains my honor to have this opportunity to greet and meet all of you through the cyberspace. Time flies, and a lot has happened around the world during the past year. Whether at the domestic or the international level, I dare say COVID-19 and its impacts and consequences are some of the most common topics being discussed around the world. The arbitration community is no exception. COVID-19 undoubtedly has an impact on the conduct of international arbitration. However, not all the impacts are negative. Among others, COVID-19 has highlighted one of the key attributes as well as attractions of international arbitration, namely flexibility. As a matter of fact, the key arbitration institutions around the world respond to COVID-19 very quickly, and if I may say, flexibly. Virtual hearings or hearings through video conferencing facilities are now far more common than before. Take the Hong Kong International Arbitration Center as an example. Currently, about 60% of our hearings are conducted via video conferencing facilities with other technological support, including electronic presentation of evidence. Traditional litigation, for reasons that are understandable, came to a complete or partial standstill in some jurisdictions. On the other hand, many arbitration institutions soldier on with their operations. So far, the Hong Kong International Arbitration Center does not have to cancel any hearing despite the outbreak of COVID-19. Viewed from such perspective, not only has international arbitration survived the fight against COVID-19, it has come out stronger and reinforced its attractiveness. Fighting against COVID-19 requires international cooperation. Again, the same is equally true in the context of international arbitration. There are certainly many different areas that merit attention. For the purpose of brainstorming, may I mention two aspects. First, the holding of virtual hearings requires the support of technology. Yet, there are issues such as cyber security, as well as compatibility of software and applications. Cybersecurity is particularly important, bearing in mind the confidential nature of arbitration. Second, the growing popularity of virtual hearing has also raised the question of whether there is a need for some sort of best practices or code of conduct for conducting virtual hearing. Different arbitral institutions have issued different guidelines for virtual hearings, and they focus on different aspects and different areas. My focus is how to ensure that virtual hearings can be conducted without in any way compromising due process and fairness, so as to avoid unnecessary controversies at the stage of enforcement. The issues that I have just highlighted deserve discussions among arbitration institutions. Last year, we signed the Beijing Joint Declaration of the Belt and Road Arbitration Institutions, which set out our cooperation mechanism. One of the objectives of the cooperation mechanism is to promote the research and exchange of expertise of dispute resolution in regions and countries along the Belt and Road route. With the changes to the international arbitration landscape brought about by COVID-19, it would not be a bad idea to invoke the cooperation mechanism for the purpose of researching into issues such as those mentioned earlier, and of course, other issues that may arise as a result of COVID-19. In any event, the Hong Kong International Arbitration Center looks forward to fostering even stronger ties with other arbitration institutions, including CTEC and those along the Belt and Road routes. Cooperation, I believe, is one of the best ways to achieve mutual benefits. On this note, it remains for me to wish China Arbitration Summit 2020 every success, and I look forward to having a chance to meeting all of you in person. Thank you very much.
Thank you very much, Mr. Yuan. I think he has. We are particularly encouraged by his remark that the international arbitration community has come out stronger than before in coping with COVID-19, and also very inspiring statements on the two particular issues involved in COVID-19 arbitration practices, namely the technical challenge as well as the legal question of code of conduct or best practice. And obviously, international cooperation is all the more important nowadays. So thank you very much again. Our next speaker is Gary Baum from Singapore International Arbitration Center. He is the president of the center. But before he joined Singapore, he has already been involved in over 900 arbitration cases. This world's most formidable arbitrator. Let's hear what he has to say.
Hello. It's an honor and pleasure to be with you today, even if only remotely, even if only virtually. My topic today is international arbitration in the time of the pandemic, in the time of COVID-19. In many ways, one might see the pandemic as a challenge, a difficult challenge, which dispute resolution might not be able to overcome. Many aspects of our lives have been disrupted, have been put on hold because of the pandemic. Schools, businesses, other aspects of our life have been delayed, put on hold during the last 7 months. What has happened with international dispute resolution, and in particular, what has happened with international arbitration? International dispute resolution in national courts has found the last 7 months challenging. In many national courts, trials and other aspects of the litigation process have been suspended. Some national courts, of course, have conducted remote hearings, albeit on a reduced scale. In other jurisdictions, however, the doors of the courthouse, the availability of justice has effectively been put on hold, has been suspended. The inability of people, counsel, parties, judges to congregate has prevented courts from conducting hearings and the litigation process from continuing. Countries have responded in different ways, but in general, it's fair to say that the pandemic crisis has posed very difficult challenges for national courts around the world. International arbitration has faced, in some ways, the same set of challenges. COVID prevents arbitrators, counsel, and parties from getting together in the same hearing room in the way that was frequently done prior to lockdown. International arbitration, in a sense, might have been thought to be particularly vulnerable. It requires, by definition, parties from different countries to travel typically to one place, to the place or the seat of arbitration, and there to have a concentrated hearing for a set number of days scheduled in advance. The pandemic prevents that. It prevents international travel in many respects, and equally it has prevented, over the last 7 months, people, arbitrators, counsel, parties, from getting together in the traditional hearing format that we were all accustomed to. Despite that, international arbitration has responded to the pandemic not as a problem, not just as a challenge, but also as an opportunity to demonstrate again how international arbitration can be more efficient, more expert, more expeditious than the alternatives, than national court proceedings. Virtually every major arbitral institution has continued to conduct its activities. Virtually every arbitral tribunal has continued to conduct proceedings over the past 7 months, notwithstanding the pandemic. Arbitral institutions continue to receive filings digitally of requests for arbitration. At the Singapore International Arbitration Center, for example, the number of requests for arbitration filed over the past 7 months has been significantly greater than that over the 7 months in 2019, which was in any event a record year. Other arbitral institutions are also seeing very significant numbers of new filings, in part because of the economic dislocation that has resulted from the pandemic. The virus has not stopped parties or their lawyers from commencing arbitrations, though, from commencing international arbitrations. And likewise, although hearings are different today, hearings are being conducted and arbitrations are proceeding apace to a final award, which is being issued by arbitral tribunals, sometimes using electronic signatures. Those hearings look different than they did prior to the pandemic, although they put to use some of the procedures, some of the technologies that had already been experimented with prior to lockdown. In particular, prior to the pandemic, arbitral tribunals had in some cases been conducting case management conferences or procedural hearings by telephone conference call, rather than, as historically was the case, the counsel and arbitrators meeting physically. In addition, in a number of cases, arbitral tribunals had heard witnesses remotely, heard witnesses using video conference technology where the witness was at a remote location, often in another country, and the arbitral tribunal and the parties and their counsel in a single location in a different country. That type of remote video conference witness testimony raised questions. Could it effectively be conducted? Was it a fair and efficient way to conduct the arbitral process? But the answer to those questions was almost always yes. Arbitral tribunals found ways using technology to enable examination and cross-examination to proceed. And sometimes a 360-degree camera or some other technological solution to ensure that witnesses wouldn't be coached or have inappropriate access to materials was utilized. Sometimes another person would be physically present with the witness in the location where she or he was giving testimony, but arbitral tribunals were able to hear witnesses who, for whatever reason, couldn't travel to the place or the seat of arbitration. Once lockdown conditions began, much more of the arbitral process, much more of arbitral hearings moved online and began to be conducted remotely. Tribunals around the world conducted virtual hearings or remote hearings where all of the counsel and all of the members of the tribunal would be at separate locations. Using new video conferencing platforms, which had been experimented with prior to lockdown, but which really came into their own in the last 7 months, such as Zoom or BlueJeans, Teams or WebEx, arbitral tribunals would hear witnesses located in one country, where all three members of the tribunal would themselves be in different locations, often in different countries. Arbitrators would work from home, just as counsel would do. This enabled the arbitral process in some ways to continue, and not just continue, but to continue more efficiently. No longer did everybody need to get on an airplane to fly and stay in a hotel in a remote location. Instead, everybody could work from home, and the arbitral process would proceed nonetheless. Of course, there are challenges to that type of remote hearing, challenges relating to accessibility of documents, to ensuring, as with remote testimony prior to the pandemic, that there was no inappropriate witness coaching, challenges where members of counsel's team for each of the parties would need to find ways to communicate with one another. But all of those challenges were met. All major arbitral institutions developed guidelines or rules of practice, codes of conduct for remote hearings. KCAB was one of the first in publishing a set of guidelines for remote testimony, but SIEC itself in the last month, the ICC, other arbitral institutions also have developed guidelines for how remote hearings can be conducted. Importantly, while national courts in many cases were suspended or entirely shuttered, international arbitration continued to make justice available, accessible to businesses and states around the world. Looking forward, looking to the future, I think many of these lessons, many of the lessons learned over the last 7 months will continue to be applied even when physical hearings again become routinely available. Many of the techniques, remote hearings, can be used in smaller cases when witness testimony is less critical or when oral submissions by counsel are the most important aspect of the hearing. There are challenges to remote hearings, to be sure. Time zones where parties and their counsel are located all around the world can make it difficult to schedule an ordinary hearing day. But we need to, and arbitral tribunals have, reconceived the notion of a hearing. A hearing doesn't necessarily need, as it was in the past, to be a concentrated set of proceedings where for 5 days from 9 a.m. until 5 p.m. or 6 p.m. every day, the arbitrators and counsel engage with one another. Instead, hearings can be rescheduled and distributed across a longer period of time, where shorter segments to accommodate for Zoom fatigue or similar issues can allow the hearing to be scheduled in a more efficient and expeditious manner. All of these lessons will continue to be used after the pandemic subsides and after we're able to meet physically. In some cases, we will choose no longer to meet physically because we can more efficiently and expeditiously do what it is parties want us to remotely, just like we had this session. Thank you.
Thank you, Mr. Baum. I think we are particularly pleased by the conclusion that although there are challenges, the challenges are generally met, and there are many opportunities actually being seized by the international arbitration community, and also the concept of hearing being already reinvented. We will hear a lot more in the next session on online hearing. Obviously, Mr. Baum's presentation is more like a general assessment of the COVID-19 responses, although with special references to the Singaporean experiences. Our next speaker is by Ismail Salim, who is the director of Cairo Regional Center for International Commercial Arbitration. Let's hear his African and Middle East perspectives.
下午好 Ladies and gentlemen, my name is Ismail Salim. I'm the director of the Cairo Regional Center for International Commercial Arbitration, the PERSICA. It is a pleasure and honor to be part the China Arbitration Summit through the CATAC online conference. Today, I'm going to shed light on CERSECA's response to the COVID-19 crisis. The COVID-19 crisis brought about a wave of new issues that affect the administration of arbitral proceedings. While it is true that Egypt has never instituted a full lockdown, CERSECA tailored its response to balance the following: safety concerns, avoid disruption of the proceedings, and due process. In its response to COVID-19, CERSECA has encouraged its users, arbitrators, parties, and counsels alike to privilege electronic means both for hearings and submissions. Where hard copies are necessary, CERSECA was open first once a week, and in April, twice a week. CERSECA has also allowed physical hearings to take place at its premises, with the requirement that parties send no more than 3 representatives in order to maintain a safe distance between attendees. And the CERSECA has also offered the possibility of holding virtual hearings. During June and July, the center was open to the public 3 days a week, while maintaining its original requirement that in-person appearances at the center be limited to those strictly necessary, and that hearing should remain remote wherever possible. Since August, the center is open to the public 5 days a week. Further, internal safety measures included dividing CERSECA's 35 personnel members into 2 groups, neither group coming into contact with the other, so as to ensure the continued running of the center services in the event of a COVID-positive case in either group. Since the end of April, several hearings have been conducted by video conference, thereby minimizing disruption of the arbitral proceedings. In general, the parties, their representatives, and the arbitral tribunals have been cooperative, with a growing trend towards using technology to accommodate the restrictions associated with the COVID-19 crisis. In some cases, parties have preferred partial remote attendance or have attended in greater numbers than the per room limit set by the center. Hearings have gone smoothly and have allowed the efficient examination of witnesses and experts, and excess attendees were seated in a separate hearing room that was connected to the main hearing room via video conference, allowing the center to maintain social distancing guidelines while ensuring due process. As is the case for many arbitral institutions, CERSECA has urged its users to transition to electronic means of communication and submissions, as well as to privilege remote hearings where possible. From 1st of March 2020 until 20 August 2020, 23 hearings took place at CERSECA, of which 12 hearings were held with full in-person attendance, with 9-person maximum capacity in the main hearing room, and the possibility to have several hearing rooms connected to ensure social distancing. 4 hearings were held with partial in-person attendance and remote attendance. 6 hearings were held via video conference. 1 hearing was held via teleconference. And finally, CERSECA also hosted 1 remote witness examination via video conference in an ICSID arbitration case. In other cases, tribunals and parties opted for alternatives to hearings, such as the submission of additional written memoranda. Thank you very much for your kind attention. 谢谢你，再见。
谢谢你。I think he has gave us a marvelous perspective, from the Africa and the Middle East. In particular, I think the double grouping of the staff and the connected room, that practice was really innovative and particularly interesting. Our sixth speaker is Rana Sajid, who is the president of Center for International Investment and Commercial Arbitration from Lahore, Pakistan. I have to admit that I had the privilege of working with him in setting up this CIRCA Arbitration Institute. Let's welcome Rana to speak online. Welcome.
Thank you for the kind introduction, Professor Shan. It's a pleasure to be participating in this conference. I'd like to thank CTAC, especially Vice Chairman and Secretary General. Can you hear me? Okay, sorry. I thank the Vice Chairman, the Secretary General, Mr. Wang Chengji, for this kind invitation. It's an honor to be sharing the panel with such eminent practitioners and leaders of arbitral institutions. Last year when I was in Beijing to attend the Arbitration Summit 2019, nobody knew that in a couple of months the world will be such a different place. We're here now, thanks to CTAC, that we are still organizing this conference, and this is a credit to the marvel of technology, I suppose, that we can still organize such conferences. But I think in the past 6 months, we've heard the word online, virtual, remote quite a bit. And so we live in this so-called new normal. We have adapted quite well to this new reality. But I think one of the questions it raises is, how normal is this new normal? Is it appropriate? Is it effective? Is it suitable? The reason why I ask this is because I wonder if this is an active or passive choice. So if parties still have the choice of virtual hearings or in-person, face-to-face hearings, would they still choose the latter or the former? I think going forward, it seems that this is the new normal and most likely it is sustainable. But I think that choice should still stay with the parties. Of course, there are time and cost efficiencies involved. A lot of parties prefer to just opt for virtual hearings for cost reasons as well. But I think there's something to be said about in-person hearings. And I think that is one choice that should still stay with the parties. Of course, there are other benefits as well because of the COVID-19. We've been able to attend conferences, webinars, training workshops. A lot of the institutions and individuals have been very generous in terms of free content and free resources. So those are welcome developments. But I think we need to be mindful of what will happen perhaps in a year or two when we think whether this new normal is still sustainable. So I think ideally a combination of both, the traditional method and the new methods involved in technology would be a viable option. In terms of the response of arbitral institutions, I can speak a bit for SICA. So we worked on our online filing system quite closely because we realized, especially in Pakistan, where there wasn't the option of online filing for courts. So we figured this is a good opportunity to promote our services. So we worked on that. We also reviewed our rules to ensure that we have the virtual hearing option still available. Based on my conversations with the Global Advisory Board, we realized that there is no need to update our rules as such because there is a provision whereby the arbitrator has broad discretion in terms of deciding whether or not they can conduct hearings virtually. So we did a bit of that. In terms of arbitral institutions' response in general, I think it's reassuring and great to see a lot of the joint statements coming out, a lot of the cooperation and collaboration being discussed. But I think at some point, beyond this exhibition of spirit of collaboration, I think arbitral institutions need to sort of think and go above and beyond. And by that, I mean not just offering digitalized services, not just offering online filing services, virtual hearings. Those are great, I think. But I think beyond that, I mean, I'll give you an example. So what SICA did was a few months ago, we started offering discounted rates on our expedited arbitration services. What we did was we offered a 40% discount on our services for expedited arbitration, whereby a sole arbitrator renders an award within 90 days. the idea basically was to facilitate the MSMEs, the micro, small, medium enterprises. Because I believe that in a lot of countries, those MSMEs serve as the backbone of the economy. And I think if you consider the fact that although a lot of businesses, pretty much all businesses are affected by the COVID-19, but I think the smaller businesses have taken a bigger hit. So they're in a bigger problem, so to speak. So I think to ease that burden of these financially distressed companies, the idea was, first of all, to make sure that costs are not a deterrent to dispute resolution. So already they have a problem, a financial problem, so they should be more open to resolving disputes through arbitration. So that was one of the ideas. And I think that is one thing that perhaps some arbitral institutions could consider, that, beyond the digitalization, perhaps focusing on the smaller businesses, having a sharper focus on them, could not just benefit those small businesses, but economies at large. So I think that's one of the things that we've learned during this process. In terms of user satisfaction, I think arbitration, I will not go into the detail of the criticism, but I think perhaps one of the dividends of the COVID-19 is that we could go back to the drawing board and rethink and perhaps even redesign some parts of this arbitration process. Because I think this is a stark reminder that, beyond just digitalization, there are other concerns about this particular process. So I'll give you a quick example. Consolidation of proceedings. Now, that's usually within the discretion of the arbitrator, of course, pursuant to the institutional rules. But in some cases, perhaps the arbitrators could have a different mindset, whereby they're a bit more proactive in consolidating proceedings, coordinating proceedings, again, for reasons of cost efficiency. So I think perhaps a shift in the arbitrator mindset and the institutional rules and approach to that end could help. Because again, I think the criticism is that it's not that time and cost efficient anymore. A lot of people think that arbitration is essentially litigation in disguise. It doesn't look like, work like, or feel like arbitration anymore. So the idea basically is that beyond the digitalization, we discuss other things that could make this process more efficient and effective for the users. Because at the end of the day, it's the users who need to be satisfied with the entire experience and process of arbitration. Briefly about the Belt and Road Initiative, because this is one of the topics that has been discussed, and that is why we were here last year also. And it was commendable that CTAC took the initiative to have around 40 arbitral institutions, their representatives around the table. We signed this Beijing Joint Declaration, which is a commendable initiative. And as far as the Pakistan part is concerned, the Pakistan component is called the China-Pakistan Economic Corridor. It is one of the key components of BRI, primarily because of this strategic seaport called Gwadar Port. And of course, people in Pakistan are very excited about this initiative because there's huge amount of investment coming into Pakistan, and Pakistan enjoys long-standing ties with the Chinese. And this is where I'm very pleased, because last year when I was in Beijing, CTAC and CICA signed this cooperation agreement whereby, in addition to other services, we decided to offer services where we jointly resolve disputes, especially for Chinese investors coming into Pakistan. And my understanding is some other institutions did the same. And those who did not, perhaps this might be a good time to consider that, whether they enter into a cooperation agreement or MOU with CTAC or other organizations that are relevant. So the idea basically is that across the Belt and Road, we facilitate dispute resolution. Because if you think about it, it affects, I believe, 60 countries around the world, and I believe 40% of the world's GDP. So a lot is riding on it. The stakes are very high. So we're in this together, which is why I think from the standpoint of arbitral institutions, at a minimum, I think we need to ensure that disputes are resolved effectively and efficiently. Finally, in closing, I'd like to end on an upbeat note, look to the future with an optimistic outlook. I hope that next year, although we can still have an online conference, but hopefully the COVID-19 is behind us, things have improved, and we can actually meet in person, because we could have all these online interactions and exchanges, but I think in order to have meaningful exchanges, it's always good to have that face-to-face interaction, meeting people in person, having lunch with them, having a casual conversation with them over coffee, because I think that is how you actually develop and build relationships. And that is also how you build consensus when it comes to resolving disputes. So with that hope, I would close, and I'd like to thank CTAC once again, and I wish them a successful conference. Thank you.
Also, thank you, Rana, for the inspiring presentation. I think I'm particularly grateful for his points from the perspectives of SMEs and also the attention paid to the financial burden of clients, which I think is very important for the Belt and Road Corporation. Our next speaker is Marcela Pinoy, who is a board member of Center for Arbitration and Mediation of the Costa Rica Bar Association. Let's welcome her. She is the only woman to speak in our panel. She will speak from video as well, so it's not allowed.
Greetings from Costa Rica to all of those who have joined us in this Virtual Arbitration Summit 2020 organized by CIETAC, as well as to my co-panelists. I want to thank CIETAC for inviting me on behalf of CAM to be part of this Virtual Arbitration Summit 2020 and to deliver these remarks on the topic Challenges for Arbitration Posed by the Pandemic, the Need for Countermeasures, and the Importance of Experience Sharing of Arbitration Institutions. COVID-19 pandemic disrupting effect on the global economy has impacted international arbitration, both commercial and state investor-related disputes. As a result, it has put forth the challenge of finding solutions to mitigate the negative effects on pending arbitrations and has also generated new disputes that may themselves be more difficult to progress due to safety concerns and public health restrictions. The adverse consequences of the COVID-19 pandemic make it more critical ever that parties, counsel, and tribunals give due consideration to implementing case management techniques designed to make arbitration fair and efficient. Arbitral institutions have reacted promptly to the challenge and are implementing guidelines that can ensure that disputes will continue to be resolved on a fair, expeditious, and cost-effective basis, and have acknowledged the importance of the role that parties, counsel, tribunals play in pursuing this task. In this regard, relevant contribution has been that of the ICC Court of Arbitration, that has issued guidance notes that recalls the procedural tools available to parties, counsel, and tribunals to mitigate delays generated by the pandemic through greater case management efficiency, and provides guidance concerning the organization of conferences and hearings in light of COVID-19 considerations, including conducting such conferences and hearings by audio conference, video conference, or other similar means of virtual communication. The use of technology notwithstanding has not been exempt from challenges. Discussions about if it guarantees the transparency and if it is effectively allows the tribunal to properly perceive aspects such as body language of witnesses and experts, and that of how to handle the disruptions to which technological means are exposed. The pandemic has also brought about the challenge and need of the parties, counsel, and tribunal to adapt themselves to a new system that might take them away from their comfort zone. It has also raised the question if there is a right to a physical hearing in arbitration. For good or bad, the pandemic is a reality that has obliged parties, counsel, tribunals, and arbitral institutions to look for new ways to implement countermeasures and case management techniques so arbitration can keep being the unquestionable, appropriate means to solve international disputes. Among the suggested management techniques, just to name some, we can highlight disposing expeditiously of certain claims or defenses, resolving the issues in dispute in stages by rendering one or more partial awards. When doing so is likely to result in a more efficient resolution of the case. Identifying whether the entirety of the dispute or discrete issues may be resolved on the basis of documents only, with no evidentiary hearing. Identifying issues that may be resolved by agreement between the parties, identifying issues that may be resolved without witness and or expert evidence, or on the basis of written questions from the opposite party or the tribunal and written answers from the witness or expert. Considering whether site visits, inspections by experts can be replaced by video presentations or joint reports of experts using either audio conference or video conferences for conferences and hearings where possible and appropriate, and definition of etiquette rules that can contribute to a successful virtual hearing. This brings up the question, are we before a new era in international arbitration? An era in which arbitral institutions are challenged to adjust time in order to preserve credibility, transparency, and professionality in the system? I think the answer is yes. Under this scenario, the Beijing Joint Declaration of the Belt and Road Arbitration Institutions of November 7, 2019, endorsed by more than 40 dispute resolution institutions, among which are some of the main arbitral institutions of the world, is very timely and serves as an umbrella agreement to facilitate conversation and collaboration amongst international arbitration practitioners that will continue to strengthen the Belt and Road Initiative arbitration system. The CAM, Arbitration and Mediation Center of the Costa Rican Bar Association, has been one of the centers that not only has enthusiastically endorsed the Beijing Joint Declaration, but also seeks to strengthen the bonds of friendship with CIETAC through the implementation of the cooperation agreement signed in September 2018. In this regard, there is no doubt that the principles, objectives, the functions, and the activities laid out in the cooperation mechanism are essential to face the challenges posed by the pandemic. This virtual arbitration summit 2020 allows a vivid experience in the right direction that will contribute to lay out the steps to be taken in the future. CIETAC's successful endeavors in carrying out this arbitration summit confirms the value and need of cooperation and experience exchange between arbitral institutions. Thank you.
Thank you, Marcela, and for your Latin American experiences. I think we have running short of time. We have a last speaker who is a senior mediator from CEDR, the Center for Effective Dispute Resolution, based in London. Professor Malik Dallan. He is also a professor at Queen Mary, University of London, Queen Mary, the School of Queen Mary. And he is also a senior fellow at Harvard University, the negotiation task force. So let's welcome him to deliver a speech by video presentation.
Ladies and gentlemen, it is my great pleasure to join you, even if virtually, during the 2020 China Arbitration Week and China International Arbitration Summit, jointly hosted by CIETAC, ICSID, and ACLA. I do sincerely cherish this opportunity as a mediator and a neutral, not only because it is the most important arbitration event in China and the annual calendar date for the international dispute resolution community, but because it is vital that we see our friends from Washington and Beijing sitting together and thinking together about the threats and urgent measures for stronger international arbitration cooperation in response to the pandemic. Our global challenge now. International trade is suffering. Companies around the world are closing shop, canceling orders, and ceasing production. Businesses that are linked through a worldwide network of global supply chains are defaulting. And the reality is that no effort by any one given country alone will be sufficient to reboot the global economy. International investment is also shrinking as international investors see market future with a negative outlook. Even maintaining existing investments, the progress of investments, direct or otherwise, is at serious risk of delay due to the pandemic. From the broader multilateral perspective, the trade conflicts that preceded the global health crisis have only deepened. Breach of duties under trade accords or regional agreements are inevitable, but it must not breach our trust in the international system and peaceful mechanisms of dispute resolution. In the 20th century, mankind has achieved a great deal. We reached the moon. We overcame many difficulties and created civilized, multilateral legal architectures to advance a peaceful and prosperous global community. Today, we face an unprecedented meltdown in the multilateral system. And if there has ever been a need for internationalism, it is now. Peaceful, civilized, and efficient resolution of increasing disputes is the safety net of all humanity. And communication exchange in multilateral cooperation is the best safeguard for dispute avoidance. I hope that the G20 meeting in November, following the US elections, will provide us an opportunity for international wisdom and communication. Goodwill goes far. Let me turn to dispute resolution today. Our current international dispute resolution mechanisms are simply not sufficient nor efficient to handle the waves of disputes, nor are multilateral organizations. For that matter, the WTO, for example, a member-driven organization, is a good or bad example, I should say. I see in international mediation some light. CEDAW is called upon frequently by international organizations and governments to enhance the business environment and civil justice through developing the use of mediation within their jurisdictions. We plan to do more of that with CTAC. Other than my work with CEDAW and the university, our organization, Institution Quraysh for Law and Policy, or IQ, was established in 2005 by a special charter in the United Kingdom with its status and international track record of proactively promoting a global commitment to the rule of law. We further established IDR, or the International Dispute Registry, as a powerful idea about managing the life cycles of disputes. It is what we call institutional dispute regulation. We take pride in what we believe and what we do. We think of it as our traditional values in keeping with integrity, cultural commitment, and of course, resilience. As for the BRI, those of you who were here last year might have heard me speak about the Belt and Road Initiative, BRI, in the context of mediation. I'll not repeat my advocacy on this point because you will find it in my articles and writings. Suffice it to say that China has always been one of our research foci or focuses. We recruited specialists to serve as research fellows and established our evolving BRI law project in London. I myself have written the first articles on BRI law in the UK, and at this time of great doubt, not for merely research reasons, but also to promote a cause for collaboration, I made it a point to publish an article last month in the Harvard International Law Journal under the title Envisioning Foundations for the Law of the Belt and Road Initiative, Rule of Law and Dispute Resolution Challenges. Notwithstanding the recent challenges with developing countries within or participating countries within the BRI, it is the largest global program of infrastructure investments in the world today. Works carried out under the rubric of BRI is expected to amount to several trillion US dollars by the 2030s and will exceed and take place in over 65 countries. There are, however, increasing legal challenges facing investors and states on the question of how project disputes that arise with works carried out under the BRI will be settled, given the lack of an overriding BRI authority nor a multilateral framework. What is important, however, is to provide a deeper legal understanding of how dispute resolution is carried out now. And I believe the BRI might just in time give rise to new legal norms, such as harmony, and institutions, the outlines of which are already visible. The China International Commercial Court is a good example. One essential development will be the creation of a dispute resolution regime, with the urgent need for efficiency to be at the core. ISDS as a start, and institutions that respond to the area of challenges posed by projects carried under the BRI. Finally, there is a larger conversation that awaits us about intergenerational equity. The differences in the expectations and views between generations, our children, are bigger than those between countries. The tiny virus opened up jurisprudential debates about the future of disputes, which will cause delays and negatively impact the speed of development or mitigating issues such as climate change. What we have now is just a practice. I look forward to witness and contribute to strengthening this bridge of international cooperation, legal and arbitration related. And on behalf of myself and CEDAR, please accept my sincere appreciation as a friend of both Secretary General White and of CTAC for your invitation and the opportunity to share my thoughts. Thank you. Ladies and gentlemen.
Thank you, my last speaker, certainly not the least. As much as we were impressed by his efforts in promoting dispute resolution, in particular mediation, we were impressed by his scholarship and commitment in the Belt and Road dispute resolution in particular. Indeed, it's a shared interest because Belt and Road dispute resolution is something that we have worked out on at Tianjin University. We just published a book by Cambridge University Press entitled China and International Dispute Resolution in the Context of the Belt and Road Initiative. Time flies. We have, most of them are recorded presentations, so we, and also we started late, and hence the delay in the proceedings. But as the norm, I have to summarize a bit quickly. If I have to summarize, I think the first thing that came out would be great effort, great success. As highlighted by many speakers, the great efforts have been made by all the institutions, leading to a greater success in coping with the COVID-19, with increased cases being handled, with not further delay or added delay. Second, I would say that major changes and permanent impact. The COVID-19 has brought up not small, but major fundamental changes in international arbitration, particularly the form, the conduct of hearing. We heard about hearing reinvented. And this change would not be temporary, as many of them already said. It will be a lasting change, probably a permanent change. Third, divergent experiences, more cooperation are required. And obviously, different institutions, there are many shared practices, but there are many differences, as highlighted by Mr. Yuan from Hong Kong International Arbitration Center. They say there is significant need for enhanced global cooperation, indeed, as mentioned by many in this context. That's why the Belt and Road Initiative, the Beijing Joint Declaration, is all the relevant. With this, I conclude this session and would invite you to join me to thank all of our 8 speakers for their insightful and inspiring presentations. The second session, now I hand the moderator's role to our next moderator, who is Jared Fisher, and she is a senior counsel from ICSID. Let's welcome her.
Hello, everyone. My name is Geraldine Fisher, and I'm a legal counsel at ICSID. Today, we're going to talk to you about emerging best practices for virtual hearings. The arbitration community has long discussed the promise of technology, but until recently, it has only used technology for limited purposes. In the past few months, I think it's fair to say that we have all learned a lot about how we can use technology in arbitration. We'll start off today's session with a video. This video contains tips and practical considerations from arbitrators and counsel who have recently participated in remote hearings. After the video, 2 of our arbitration experts will give their perspectives. Then we will field questions from the audience. We welcome your comments, and we hope that you will share your experiences as well as your advice on remote hearings with us. We've also provided you with a comprehensive bibliography for remote hearings. We highly recommend this resource of excellent templates, protocols, and articles. So without further ado, let's hear from our colleagues around the world. A threshold question is to determine whether the applicable arbitration rules allow for remote hearings. For example, under the ICSID rules, remote hearings are clearly available.
I have developed, I think, a pathway, a pandemic pathway, and published on this. And my point has always been that you need to go through this test, whether the tribunal or the parties, to look into the different options available under the parties' agreement, the law, or the rules. Now, obviously, if the rules, the applicable procedure rules, are different from what the specific law of the seat provides, the tribunal needs to conduct a test to see whether the specific rules dealing with technology or virtual hearings is of a mandatory nature or not. I, for one, would find it very difficult to perceive a situation where a law would mandate or a rule would mandate physical or virtual hearings as being mandatory. But again, it's part of the analysis that the tribunal needs to conduct.
If a remote hearing is going to proceed, the next step is to figure out the technological needs as well as the logistics. All hearing participants need to have certain equipment for a remote hearing. The basics include a computer with an internet connection. We also recommend an Ethernet connection because that allows for better connectivity. There are also accessories that make remote hearings easier. For example, I like my headset with the attached microphone.
From a technical point of view, what you need is, of course, professional equipment. With an iPhone in the corner of the kitchen is not a good place to have an ICSID hearing. You need professional equipment, you need at least 2 screens, you need good cameras, you need good microphones, loudspeakers, and everyone needs to have them.
We are here in my office in Brussels, where I conduct my virtual hearings. So what you see here is my screen. It's a large screen because I have one large screen because I prefer one screen over 2 or 3 screens. Because it gives you a quicker overview of what is going on in the case. And what is interesting of this monitor is that the software allows you to partition the screen. On the top left, you see a Word document that's open. That is notes, where I take the notes of the hearing, whether it's witnesses or argument. And then on the left bottom, you see there the transcript is running of the hearing. Top of the screen, you see a camera. You see a little black lid on it. That is, if you were to this, then unauthorized people can't see you. There is on the left-hand side what you see is a microphone that is as a specific request by court reporters in a number of cases. They want to have better sound for court reporting. So what I did, I bought a USB microphone, which is a World Century USB. The advantage of this one is not only the sound, but also it has a separate mute button, which is quite useful.
On my main laptop, I was running the video conferencing platform, and also alongside of that platform window, I was running a smaller window where the chat function of WhatsApp was being run to allow brief conversations within the tribunal. So that was my first laptop. My second laptop was loaded with all of the exhibits and pleadings and legal authorities so that I could pull them up very quickly if I needed to during the course of the proceeding. And then I had 2 iPads. One iPad ran the transcript as one would do in an in-person hearing. And then on the other iPad, I had all of the demonstratives and the witness examination bundles loaded.
So first, it is critically important to have a sophisticated IT platform that can manage virtual hearing by connecting multiple sites in multiple jurisdictions. This could be a challenge if speed and connectivity of internet access varies depending on the sites. And also, audience participants, it's better to have good headset to transmit sound clearly, and you better to have good camera and adequate light so that you can clearly see the facial expression of speakers.
How you set up your equipment is also very important. The other thing that you must remember is that everyone in the remote hearing can see you, so you have to remain cognizant of that.
A lot of people have their camera wrongly placed. In fact, a lot of people make the basic mistake of looking down at their camera because their camera is on a laptop often and it's positioned quite close to them. What you don't realize is that for the tribunal watching that, they get what is called an up nostril effect, which is seeing more than you want to see. You're not seeing the advocate properly, you're seeing them in a distorted way, and it looks very awkward. So you need to try and have your setup in such a way that you can actually look directly at the camera and imagine what that looks like to the other person who's looking at the screen.
And in general, the sound quality is much better if participants do not use room microphones or computer microphones, but rather use dedicated headphones with a microphone in the headphones. This does not mean that participants need to look like they are airport workers on the tarmac with huge headsets. I'm using today high quality noise canceling earbuds that are very comfortable, and I've been told that the audio quality is fine with these.
Tribunal and counsel will often hold at least one preparation session to make sure that there are no connectivity issues and everyone has a certain familiarity with the platform. Oftentimes, the tribunal and the parties will hold 2, 3, or even 4 of these sessions.
So the most important thing is the tribunal makes sure that the parties have full ability to present their case. Of course, some developing countries have problems, but even very developed countries in a lockdown situation, you never know. You are in a remote area or some other technical reason, the connection is not so good. When connection is not so good, then you have big problem. So I think that the key important thing is to make sure that parties have actual ability to present their case.
And I think the proverb "practice makes perfect" sums it up. So it's basically holding a lot of test runs to make sure the voice quality is good, the picture quality is good, the internet connection works.
And of course, obviously, if all participants are able to make it to the test run, it's helpful because then you get to test the platform in reality, whether it is sustainable and stable when everyone logs in. That includes, of course, court reporters, interpreters, the witnesses, the parties, the counsel, the arbitrators.
All of this takes time and is the result of an iterative dialogue between the tribunal and the parties. And questions will be asked, things need to be tested. And it's important for the tribunal to focus, I think, on the weakest link. Which witnesses or which set of counsel have the least bandwidth, have the least access to equipment.
These types of issues are dealt with at the pre-hearing organizational meeting. During the pre-hearing organizational meeting, the tribunal and the parties should also work on and finalize a hearing protocol. While pre-hearing organizational meetings have been used frequently in arbitration, remote hearings bring new aspects that need to be addressed. These include: how will participants join the virtual hearing? Will you be using a virtual waiting room? You will also want to answer, how will you deal with technological glitches?
It is extremely important that tribunals aiming to efficiently and properly manage the proceedings to have a protocol for the remote or virtual hearing. It could be part hinted in PO number 1 initially, but definitely it may require further detailed insight and regulation in a pre-hearing order that regulates the conduct of the remote hearing. And part of the procedural issues would not just be the technology, but also what we call the netiquette, or what the parties and counsel are expected to do in terms of conducting the hearing, when to speak, when to stop, how to raise a hand, address all these matters.
2 of the most important issues to work out are dealing with time differences and also establishing the hearing schedule.
This is particularly acute for Asian parties because when there are parties all over the world, the Asian parties end up having the hearings in the evenings because it will be early morning in the Americas, middle of the day in Europe, and it'll be at night in Asia. But I think tribunals need to just be aware of the strain that that the time differences can put on parties in different ways. So if one party is fresh in the morning and another party is facing a nighttime hearing for the 5th day in a row, that can be somewhat unfair. And I think tribunals need to be sensitive to that.
So I had a hearing started from 10:30 p.m. and finished 6 a.m. for 5 days. Then I'm still recovering from such a fatigue. It is more, I'll say, it's a very difficult. In a sense, it's more difficult than I personally in DC. I travel to DC and stay in DC and coming back. So we have to think about what is the best way to accommodate. I would suggest that witness should have priority. The witness they just have to testify. The integrity of witness is the most important thing. So I think the witness goes first, followed by the counsel, because counsel should have an ability to present their case. So counsel's time zone is maybe second important thing. And then we can consider counsel's, tribunal's time zone.
Time zones. No matter how creative participants may be about sitting times, whether you start early in the morning or you go late at night, or you take longer breaks or shorter breaks, or you add days, you're still going to be dealing with some participants dialing in very early in the morning, some participants dialing in very late at night, and that can be a burden on those participants. So that has to be borne in mind by the tribunal. I think accommodations have to be made for rest, for shorter hearing times. And it's important to ensure that the burdens of the awkward time zones are distributed on both parties to the extent you can. You don't have one party always testifying at an ideal time of day and the other side always testifying in the middle of the night. Ideally, you shift around, and that also means the tribunal itself has to be flexible.
If you all meet in the same place, it doesn't matter that one witness comes from the US, another one is from Europe, and the tribunal sits in Asia. Now, if you try to do this via virtual hearing, I have one coming up next week where we basically start in the morning for witnesses from Asia, and then we break over the afternoon, and then resume at 9 p.m. until midnight for witnesses from the US. And that I assume that's going to be quite exhausting. So it's on the one hand, it's good, we can do it, and we don't have to wait for a better future where we can all meet in person again. But it's definitely exhausting, and it's definitely difficult to get everybody under the same virtual roof now.
It's useful to invite parties to set time limits in the planning of the hearings, so that there are times that the tribunal understands that a party should not be made to sit beyond, or perhaps a time that a party should not be expected to attend before that moment.
The first question is, can you extend the length of the hearing as needed to make sure that the parties are afforded sufficient time? That will, of course, depend, as it does in every case, on how many witnesses are to be heard, what's to be accomplished. Maybe you won't have to add days. But in the 2 remote hearings that I've now had successfully, one was originally a 2-week hearing, and we ended up extending it to a 3rd week to ensure that the parties would have sufficient time with shorter hearing days. The other was supposed to be a 5-hearing day hearing, and we added 2 weekend days to bring it to 7 hearing days, precisely to accommodate the disparate time zones and the need to have shorter days.
Despite all the preparation, one also has to understand that technical glitches may come up, and you have to remain flexible.
Try before, not once, at least twice. And try with your main equipment, but you must also have a backup, because things go wrong, and they will definitely sometimes go wrong, you need a backup. You need a backup system of communication, of getting back into the hearing, and you should also have tested the backup. You don't want to test it for the first time in a moment of crisis during the hearing.
The technology we're using, the all different type of the application, is good enough. Actually, even better than in-person hearing. But at the same time, I never had any hearing without any technical problem. So always technical problem happens. So we must prepare the situation.
We have not yet peaked in terms of the technology suited for arbitration hearings. People are making quantum leaps, and technology is being developed on a daily basis. And services to support online hearings and virtual hearings is proliferating in a way. But still, there are hiccups in terms of technology, especially when you stay online for a long period of time.
It can very much help if you are using an experienced technology provider, whether it's an outside provider or an institution that has in-house people who may be able to work privately with the witness in advance of the hearing, just to make sure that everything has been set up right, to test it, to give the witness comfort. You don't want to leave anything to chance for the hearing itself.
I think the key is to be patient, to have everybody work together, to find a problem and fix it, and to actually leave a bit of time for these issues in the daily schedule.
Parties also need to feel confident about the security of the platform.
That's to do with who can connect physically to the remote hearing room. And depending on the platform you use, there are a variety of mechanisms, but you might call them waiting rooms. Somebody, whether it's the institution or a remote administrator that's been hired for the case, should collect all those who dial in a waiting room, if you will, and then make sure that they are properly identified, that you don't just have abstract names or phone numbers assigned, and then only let them into the hearing room once everyone's ready and everyone has been properly identified. That prevents someone from just dialing in midway through the...
If your dispute is under a treaty that requires full transparency and open hearings, another issue that may come up is that your remote hearing may have to be available to the public at large.
The challenge really is when it comes to confidential information. So when there's a discussion about confidential information. And in that case, you have to take certain precautions. Of course, that's not unlike the current situation. In an in-person hearing, you also have to account for that. In the case of remote hearings, the secretary of the tribunal won't have an easy way to scan the room to see, for example, if somebody's raising a red flag to say, oh, should be closed, the session should be closed. So it's important that you put in place a protocol so that there's one person in charge of communicating, perhaps with the secretary, to indicate when a portion of the hearing should be closed, or if the speaker itself can flag it for the tribunal.
Tribunal and counsel should also address how they will communicate during the hearing off the record. For counsel, this means what is going to replace the sticky note your colleague sends to you during the hearing.
I think the most important thing, of course, is to set up a channel of communication using some sort of a chat function, whether it's a chat function that is used internally within a counsel team already, or set one up specifically for the hearing. But there are obviously a number of chat programs you can use, from WhatsApp to other services. But obviously it's important to make sure that everybody on the team can access it, whether it's counsel, whether it's the client, co-counsel, and that you have set up preferably different channels for communicating to the client, communicating with colleagues, communicating with co-counsel. And one thing that we have not done, but having had the experience now with several hearings, I would recommend to do is actually to also set up a chat channel with opposing counsel, because that way you can potentially resolve some issues that come up during the hearing faster without having to bother the tribunal or to interrupt the hearing even.
As counsel in particular, for remote hearings, there's a great feeling of isolation. You don't have people sitting with you. You may have one or two. Often you have nobody. You won't have the full complement of lawyers working with you, and you won't have your client with you. And that means that making quick decisions, answering questions promptly, being reminded of documents is very, very difficult. That's difficult in the course of submissions, in particular when you're getting questioned by the tribunal. It's massively difficult during witness examination, where a witness may say something and your team wants to remind you, or somebody's got an idea of where there's a reference that may be helpful in another follow-up question, but they're not in the room with you. So what you really need to do, and what I now do regularly, I think it's common practice, is you have to have a dedicated screen with you, which is actually within your field of vision, and some communication system, such as WhatsApp or some other platform, where your team can send you messages and you can respond. And what I've done now is I've been quite frank with tribunals and with judges in court when I need to take instructions in a way that I wouldn't if I was just in person. In person, you subtly will have somebody whispering to you, or you'll receive a note. I think in remote hearings, everybody appreciates this huge difficulty. So very frequently, I will say, I need to stop for a few minutes in order to take instructions and catch up with the messages that may have arrived at that point, which may break the flow, but it's critical in terms of the cohesion of your team.
The tribunal faces similar issues when they would like to confer during a hearing. To address this, they often set up a separate mode of communication, such as a WhatsApp group, so they can discuss issues amongst themselves during the hearing.
Such apps can, of course, be set up on a phone, but a tip that I got from a tribunal secretary, which I found very helpful, is that those apps can also be loaded onto the main computer screen, and then that can run just alongside the main screen where the video conferencing is shown. That's helpful because then if a tribunal member needs to send a short message to another tribunal member, one can type on the computer directly as opposed to hunting and pecking on the phone in the middle of the hearing.
One may also want to think about who is actually seen on the screen during the remote hearing. This is an issue that is also addressed in the hearing protocol. Generally, only the key participants will be seen on the screen.
Let's keep the number as small as possible, so that tribunal, lead counsel to each of the parties, and then the witness or the expert who is deposing. The others should be on video off and on mute, and so that everyone can focus and can have in a big size on his screen the images of those who are really relevant. I think that is the better solution than having 50 small screens and then suddenly someone is speaking from the second screen and you don't know where it comes from. And this also limits the number of persons who actually speak. It happens in a hearing room, and it should also happen in a virtual hearing room, that those who speak are really lead counsel, the experts, the witnesses, the tribunal. If you want the secretary at some stage, if there is a point, procedural point where you want to approach the secretary, but not everyone else.
Another question is how to handle presentations and the display of key documents such as exhibits during a remote session. Counsel often uses the share screen function to display both their PowerPoint and key documents.
First, I have one advice for counsel, and that is if one counsel is speaking or examining, he or she should never be at the same time the person responsible for the document, because it distracts. You have to start looking for the document, trying to get it up. It does not get up, and you are distracted from your presentation or examination. It should always be a second colleague.
And so what becomes essential is to have a very, very easy electronic bundle where anybody can navigate. And the key to that is as many bookmarks as possible. That means that if you've got a large bundle or a series of bundles, you've got bookmarks in the PDF where anybody can just click on them like tabs. And actually, once you get the hang of that, it's much, much quicker and much easier than a physical bundle. I've done one witness hearing, which was a disaster because the bookmarks and the pagination was not quite the same that everybody had. And so it's absolutely imperative that everybody has got exactly the same electronic bundle with the same bookmarking, same pagination.
Then in terms of showing the witness the document, I've seen this managed in two different ways. One was a case where we had a document management consultant retained to assist in the case, and that provider would pull up on the witness's screen the particular document that the witness would be examined about. In this case, the witnesses were all sent remote packages of equipment, which included several monitors, for example, and the packages were controlled remotely by the provider. So the witness had no stored documents on the screen, no ability to receive emails or coaching, no ability to quickly look at other documents. The witness was shown only what the provider pulled up for the witness. So that's one approach. Another approach I've seen work in another case is to have the traditional cross-examination bundles or binders prepared by the examining counsel, sent to the witness in advance, for example, in a Federal Express box, but not opened by the witness. And then at the beginning of the examination on camera, the witness opens up the box, pulls out his or her binder, and then is asked to turn in the customary way to tab 3 or tab 5 and so forth. That worked very well in a case I had where the parties were all more or less in the same country, so it was easy to send cross-examination binders by Federal Express 2 days before the hearing. It would not work well in a hearing where witnesses are all around the world and you're dependent on courier delivery to get to different continents in time.
If you have a very large sum of money at stake and the costs of the hearing don't matter so much, the probably easiest thing is to have a document vendor that takes care of that basically hosts everything in a cloud and might even have people that then bring up the documents when they're spoken about. I think that is definitely the easiest way for the tribunal and the parties. But of course, it's also expensive. So if you have smaller arbitrations, you can find ways to kind of replicate that. So what we've done is we've basically created an e-bundle, and then there's then again two ways how to work with that. One is to share documents through your video conferencing application. So basically, you share the screen. Or what we did a bit of a hybrid. We had a screen sharing, but the parties, the tribunal members, and the witnesses had the documents basically on a second screen, which was quite helpful. If you need to read like fine print or small drawings, you can actually blow them up, which is difficult to do when you share the screen. So basically, we used the screen sharing to kind of know where we are with the document, but everybody had a second screen to be able to kind of zoom in as they wanted and to look at the documents. And that actually worked quite well.
There are often certain aspects of witness examination that are specific to remote hearings. First of all, you have to think about the perspective of the witness.
I think logistics, first of all, is very important. Witnesses can be very, very uncomfortable when they testify. The problem with remote hearings is differences in time zone. So you want to be sure, first of all, that you're not asking your witness to testify at an unreasonable hour or an awkward time, because that just makes the whole situation even more tense. So there has to be some compromise with time zones. There has to be also some sort of leveling in terms of technology, because there are differences in the availability and reliability of the remote technology. So you've got to have your witness in a place where the time zone is kind to them, and secondly, where the technology is tried and tested, so that in the course of the exercise, if there are interruptions, the witness is not blown off course and made to feel even more uncomfortable, or the exercise becomes even less accessible to everyone because of those difficulties. So that requires a lot of, even more than you would think, technology testing and dry runs beforehand to make sure that everything is compatible and works. The reality is that it is difficult to cross-examine or examine witnesses and experts remotely. And so what that means is you must reduce the scope of your planned examination. You cannot do really nowadays the same cross-examination, direct examination that you would do in person because of difficulties with duration, attention span, all the other logistical difficulties. So what I've seen is actually cross-examinations in particular become much more focused, which is no bad thing.
The specific question is how to ensure the independence of witnesses. Parties will confirm that the entire room where the witness is located is visible, and they will also ask that the desk be visible. Some will also require the use of a 360-degree camera.
There are particular challenges that arise in respect of witnesses, and I suppose they're broadly of two kinds. The first is precisely how the witness is to be examined and cross-examined. And here there are a cluster of issues, but among them it's important to ensure that the materials that the witness has access to and the way in which the witness is sequestered for the purpose of giving the testimony is well worked out in advance. Because there is a risk that there could be either some coaching, guidance, or access to materials in a way that is not as disciplined as would occur if there were a live hearing. So that's the first cluster of issues that I think needs to be dealt with.
That, of course, you need to have agreements and protocols worked out. Who is permitted to attend, for example, with a witness who can sit in? How will that be verified, or is there a trust system? If you need to verify it, one system that has worked very well in one of the cases I did was to have 360-degree cameras distributed to the witnesses and experts, which would allow the tribunal as well as the parties to scan the entire room and make sure that there's nobody attending who has not previously been authorized.
More generally, there are some challenges to remote examination of witnesses. We see here, again, that preparation is key.
The second point to be prepared is for the parties and counsel and tribunal to agree to due process protocol. For example, the manner of witness examination, whether witness is permitted to participate in the hearing together with counsel or other party representatives, or how and whether the communications between counsel and witnesses are permitted during the hearing, whether a neutral person is better to be present at the venue where the witnesses are cross-examined. This manner of witness examination is critical in the remote settings because unlike physical setting, party or counsel which is examining the witnesses do not necessarily see what witnesses who are cross-examined is doing.
The other thing that's difficult about presentations is interventions. Because of the technology and sometimes the lag that we experience in the computers, interventions are less smooth. And what I've experienced so far is that tribunals end up interrupting counsel with questions much less, and they tend to save the questions for the end of the presentation. which of course is perfectly fine as long as one is prepared for that difference between an in-person hearing and a remote hearing.
Despite these considerations, many feel that witness testimony during a remote hearing has many advantages.
I think doing a hearing with a remote camera allows everybody in the room the identical view of the witness's face, generally zoomed up so you can see facial expressions well and often better. In a hearing room, the tribunal may be 6 or 8 feet away from the witness. The examining counsel will be on the sides of the room, perhaps seeing the witness full front when the witness turns to look at counsel, perhaps only seeing the side of the face. Party representatives, junior counsel will be further down the table, only seeing the back of the witness's head. And so different people in the room will have different perspectives about what facial expressions were made, whether the witness seemed nervous or not.
But the benefit of that virtual hearing is that we can replay video. Extremely helpful. You just take a video clip, and even our submission, we just have a linked the video clip so the tribunal can see that. So and also tribunal can always go back to a particular point and hear what witness said.
The curious thing about remote hearings when you are an arbitrator is that whilst you might not see all the body language of witnesses that you would see in a physical hearing, you actually get a close-up of somebody's face while they're testifying in a way that you never would do previously, especially for those of us who don't have brilliant eyesight. It's quite an interesting experience when you see somebody very close up on the screen testifying under cross-examination, and what you can pick up from facial expressions, from movements, from just a visibility that actually is completely new.
Interpretation can also be handled very capably in the context of a remote hearing. Oftentimes, simultaneous interpretation is used. Sometimes, however, counsel may want to consider whether consecutive interpretation may be better for a particular witness or a particular language.
And there are 2 schools. There is the simultaneous interpretation and there is the sequential or consecutive interpretation. What I have seen from remote hearings I've been involved in is that there is more into the sequential interpretation. So the witness speaks and then the interpreter speaks. But I have seen in reality that simultaneous interpretation on certain platforms is a possibility. It's exactly like turning channels, having virtual rooms for the interpreters to interpret that. So I think the services on the simultaneous interpretation side will more and more creepingly find its way into the practice of arbitration in remote hearings. One thing that I predict will happen in the very short future is that we will have machine interpretation simultaneously, multilingual on different channels, and it's just got to be as accurate as expected. But I think we're moving into that direction.
With respect to advocacy, counsel must adapt to the virtual medium.
So I think one of the principal considerations when thinking about remote advocacy as opposed to advocacy in person is that it is completely different. You cannot approach remote hearings in the same way as an advocate as you would approach an in-person hearing. Speaking to a camera and being listened to on a screen are totally different experiences. And I think in many ways that means that we as advocates have to relearn our principal craft. It's difficult in terms of a lack of eye contact. It is difficult in terms of a lack of presence and actual physical proximity, which means you cannot read the tribunal in the same way as you would if you were in the same room. You can't sense how they're reacting, whether or not your advocacy is having any impact, whether it's liked, whether it's not liked, whether it's irritating. You can't read your opponent as you're speaking. You can't see body language in the same way. And overall, you're dealing with a limitation on attention span because you can't actually grip somebody in the same way as you would do if you're there in person speaking to them directly. So that means, as an advocate, you've really got to retune and be much, much shorter and try and make an impact in a different way, which is, I think, to focus on really your key points in a way much, much more than you would if you had the luxury of being in person and you could build up and you could read the situation.
One very practical tip that is extremely effective is to look at the camera to ensure eye contact.
And even though it's a tiny nuance, but if you don't look into the camera, people get the feeling like you're not really talking to them. And I think, so one of the things to connect with the tribunal and the arbitrators is to remind yourself that it's only when you really look into the camera that people feel like you look at them.
It is important to tailor your presentation to a virtual hearing. Well, first thing you learn, and what I'm learning is, you have to look at camera. You no longer look at the eyes of audience, tribunal members, or witnesses who are cross-examining. This is a huge challenge.
Many counsel who we have spoken to have all highlighted the same thing. They say that it is important to use your time wisely, and you should focus only on the most important arguments.
Thirdly, what's very important is to recalibrate your presentation as between oral advocacy and written advocacy, because now there's much more emphasis on written advocacy because of the limitations of the technology and the limitation of attention spans. So I think having written outlines, written skeletal arguments, more detailed submissions that you can make reference to is actually not only a comfort, it's actually now a necessity.
So just to summarize, we are all still adapting to remote hearings, but we know that they offer many, many benefits, especially if we use them well. Hello, everyone. We hope you enjoyed the video. We learned a tremendous amount from interviewing these highly experienced counsel and arbitrators, and we hope that some of their remote hearing tips will be useful for you. Let us now turn to our arbitration experts who will share their comments on this topic. I would like to first introduce you to Ms. Ariel Yi. Ms. Yi is a senior partner at King & Wood Mallesons, and she is located in Shenzhen, China. Ms. Yi, after watching the video, what advice do you have for our audience? And do you have any additional thoughts on this topic?
Gary, thank you very much for having me. On behalf of myself, and I believe that the audience, we really appreciate the efforts that ICSID made into bring us this video, because this video gave us a lot of tips, which is usually we don't find in the articles, in commentaries. I believe that before this pandemic, I'm one of the many that are afraid of the new technology. I believe that before that, I never attend any webinar. I always have the fear that something will go wrong and I don't know which button to press. And because of the pandemic, we're not offered any opportunity. We don't have any choice. We have to learn the new skills and learn it quickly. And I believe that the video gave us a new product, which is before that we see many articles, comments, protocols, and video is another innovative way for the experts to quickly share their, I call it freshly baked experience. And in terms of what we have seen, that it's very comprehensive. I believe that the experts you interviewed gave us a very comprehensive coverage on how to use the devices, how to look at the cameras, how to use a separate channel to discuss among the tribunal members, even discussing with the opponent counsel, and how to handle the bundles, how to handle the witness. One thing I would like to share with you that our Chinese domestic arbitration hearing is quite different from international commercial arbitration I have experienced. Usually for our domestic arbitration, the hearings are relatively shorter, usually 1 day. It's not uncommon to have more than one hearing. Sometimes certain cases along the process may have several hearings. But for our Chinese audience, international commercial arbitration, it's usually you got one hearing. If the proceedings being bifurcated into two, maximum you will have 2 hearings. So therefore, preparing the hearing is vitally important because you don't get a lot of a chance. From the videos, I believe that the 3 things which is particularly beneficial to me. The first thing is make sure you have the online access. On a daily basis, everybody has Wi-Fi. It seems to be people taking for granted. It seems to be easy. But 2 weeks ago, I attended a conference. One of the speakers mentioned that his experience that for 1 day hearing out of Beijing and Hong Kong, the hearing was cut off for 30 times, which frustrates everybody. So even if for in the daily time, it seems to be the line is okay, but for particularly when preparing international commercial hearing, it's important that we find out, we have a backup plan as one of the speakers mentioned. The second thing I found is very interesting about using the devices. Maybe 2 or 3 years ago, I recall that we had a debate about using e-bundles. Most of the senior arbitrators, they're so used to physical bundle hard copies, and therefore changing to e-bundles always make people nervous. I recall one of the arbitrators mentioned that she tried to use e-bundle, and then one counsel questioned saying, are you looking at the bundle? Are you typing your emails? When she looked at his own computer screen. But nowadays, because of the pandemic, I believe things change quickly. People are now get used to embracing the new technology. And therefore, the tips of having 2 screens, have 2 iPads, have an iPad, have an iPhone to set up different channels will help people to quickly switch from using hard copy bundles to e-bundles. And also the comments regarding the pagination, regarding the bookmark is also very useful because this is something, maybe Chinese users are not so familiar with. But when we come to international arbitration, it's certainly very important. The third thing I found very useful is the practice. When you do the physical hearing, it's never happened that you have the whole team, tribunal member, the team of the both sides to do a rehearsal. It never happened. It's once on the day you go to the hearing room, you start the hearing. But for online hearing, we're now advised to do the rehearsal, not just once, maybe a couple of times, not just the 2 minutes, 3 minutes, but make sure. You see, I haven't done this rehearsal. Now my fish tank appear on the screen, which I didn't expect because earlier I was using a smaller screen. I didn't, realize that it happened. It's kind of weird. So those tips are very useful. I believe that we're going to learn during the course. One thing I want to share quickly with the non-Chinese audience about the legal position of Chinese court taking. Earlier, we heard that Justice Young talking about 600,000 of cases which they have online hearing. And we listen to Mr. Wang Chunjie talk about more than 165 cases. They also have online hearing. But the legal position under the Chinese law is that to conduct online hearing, consent from both parties are required. If one party refuses to attend the online hearing, the court has to postpone it. And this is because, with a good reason, because the Chinese court not just handle commercial disputes, they also handle criminal matters, family-related family matters, administrative proceedings. Most of those cases may not be appropriate for online hearing at this stage. So that's how court has this position. And when it comes to the arbitration, because currently our arbitration law hasn't been amended to address the online hearing. So that's how currently people are talking about amending the arbitration law. People are talking about amending the arbitration rules in order to pave the way to remove the uncertainty. For our non-Chinese audience, it is still important to understand the legal position on that front. Lastly, I believe that after hearing all the speakers today, I believe that parties will have all the confidence on attending online hearings. I believe that I agree with Mr. Wang Chunjie that now we have the online and the offline combination. For example, one hearing I attend is one of the tribunal members dying from a remote place, but the parties are actually in the hearing room of the arbitration institution. So this kind of combination will become more and more common, provide the convenience and cost saving for the parties. Of course, this may also raise new issues on whether, whether one of the parties appointed as arbitrators not in the room, but the arbitrators appointed by another party in the room, whether that causes any due process issues. So we're going to see how things developed. But I believe that everybody agrees that we're entering into the digital age. We're going to embrace the opportunity and the challenges. Thank you.
Thank you, Ms. Yi. Those were some excellent comments. We're glad that you found some of these tips interesting. And I found particularly interesting your discussion on Chinese practice.
Thank you.
Okay. So I'm also honored to be joined by Mr. Gu. Mr. Gu is the Vice President of the Arbitration Court of CTAC, and he can bring this important institutional perspective to the discussion. Mr. Gu, we would be grateful for your thoughts and additional tips on remote hearings, especially from your CTAC perspective.
Thank you, Ms. Fisher, and thanks for the practical and useful ideas provided by video and wonderful comments of Ms. Ye Lu. Affected by the COVID-19 pandemic, this year's China Arbitration Summit is conducted online and offline simultaneously, which is a first try for CTAC in this special time. So first of all, I would like to express my gratitude to everyone's support and participation. During the pandemic, there is no doubt that the arbitration procedures have been delayed seriously, especially the date of the oral hearing. It's very hard to determine, which has caused much complaints from parties. Hence, more and more arbitration institutions are beginning to use virtual hearing to replace the traditional physical hearing. Regarding the virtual hearing, the video just played is truly comprehensive, covering almost all the hot issues that recently have been discussed in the dispute resolution community. Experienced arbitrators and counsels also provided us with practical advice and experience. I noticed that the video firstly brought up the threshold question that whether a remote hearing is permitted by relevant rules. I completely agree with the view illustrated that the tribunals and parties should look into the arbitration agreement, the applicable law, and the arbitration rules to find answer. However, virtual hearing is not clearly available in every arbitration rules or applicable law as that in ICSID arbitration rules. In fact, in most of the cases, the applied arbitration rules and applicable laws are silent on this issue. And the decision on virtual hearing is made under discretion of the arbitral tribunal. It is obvious that the virtual hearing is playing and will continue to play a significant role in the field of arbitration. I believe that an important work to do next is to reform the legislations and make clear the availability of virtual hearing in arbitration. The video also discussed the problems and concerns that may be encountered in each section of a virtual hearing. I believe that CTAC's practice in developing online arbitration service can be used for reference and discussion to a certain extent. CTAC has designed and launched its own online oral hearing platform in tackling the challenges posed by the pandemic. Together with the existing online case filing system launched last year, it can meet the needs of the parties to file new cases and participate in the oral hearing remotely during the pandemic. According to data, the online arbitration services efficiently promote CTAC arbitration in this special time and greatly alleviate the delay of procedures caused by the pandemic. Mr. Wang Chengjie has introduced statistics I will not repeat. Speaking of the CTAC's online oral hearing platform itself, it is an exclusive system that specifically tailored for arbitration procedures. To elaborate further, the platform is unique with plenty of traits. Firstly, it is not a public system and cannot be accessed without the keywords provided by CTAC. Besides, the platform connects with the database of relevant authority, so that before each online oral hearing, the identity of Chinese participants will be confirmed and verified by the platform. The security and the confidentiality of the arbitration proceedings can be guaranteed for use. For sure, how to verify the identity of the foreign participants is the next difficult problem to be solved. It is also equipped with the technology to convert spoken word to text so that the transcript of the oral hearing can be produced simultaneously. Of course, at that time, and now we can only provide Chinese version, a transcript. More importantly, the platform can achieve the effect of physical hearing to a great extent. It supports the function of uploading, downloading, and simultaneous electronic display of evidence at any time by any party. Checking and sending the hearing transcript can also be realized through the platform. Under the control of the tribunal or the case manager, the participants in the same hearing in the same hearing room can be isolated from the hearing, so that the back-to-back mediation can be realized easily as well. Actually, some disputes have been settled by mediation through the platform. What also deserves expecting is that the English version of the platform will be launched soon. I believe it will be more convenient for foreign parties to participate in CTAC arbitration procedures. The last thing I want to say is I noticed an interesting phenomenon. Although the physical hearing is resumed in CTAC arbitration at present, but some parties and tribunals still prefer to conduct virtual hearing. I see it as a need and a tendency to normalize the online hearings. Obviously, with the use of virtual hearing, the parties may save a lot of costs. For example, parties do not need to travel from city to city, even from country to country to attend an oral hearing. Instead of renting a hearing room, they can participate attend a remote hearing at home or anywhere, as well as the arbitrator's fees on travel and accommodations. In terms of time costs, virtual hearing is much more convenient and flexible to all participants, especially to bid arbitrators and foreign arbitrators. As a result, even after the pandemic, remote hearing will still be attractive to parties and tribunals. So I quite agree with Ms. Ye's judgment. Remote technology not only has practical meaning at this special period, but is meaningful to the reform of oral hearing in arbitration as well. CTAC will continue to perfect its platform to satisfy the needs of the participants. Also, CTAC will keep developing new technologies that can simplify the arbitration procedures. I believe that it is the mission of arbitration institution to keep the pace of technology innovation and bring the convenience to the parties and tribunals. So these are my comments. Thank you.
Thank you so much, Mr. Gu. It's been wonderful to hear about CTAC's experiences and thoughts for the future. So I'd just like to take the opportunity again to thank both of our commentators, Ms. Yi and Mr. Gu, for their insight. We've already discussed the benefits of remote hearings in terms of time and cost savings, as well as reducing our carbon footprint. And we also see that there are some very interesting developments in the remote hearing area. We hope that everyone has enjoyed our session, and we wish everybody the best of luck during your next remote hearing. I understand that we will now move to the closing ceremony.
各位来宾、各位朋友，不知不觉当中呢，我们今天的论坛呢已经进入尾声。尽管大家仍然意犹未尽，但是我们不得不进入今天论坛的最后一项议程——闭幕式。下面有请中华全国律师协会会长王俊峰先生致闭幕词，有请。
尊敬的各位领导、嘉宾、专家、学者朋友们，大家好！在各位共同努力下，2020中国仲裁高峰论坛圆满完成各项议程，要闭幕了。本次论坛深入研讨国际争端解决的新形势、新挑战，“一带一路”国际仲裁合作与疫情应对、线上开庭、仲裁实践的创新发展等议题，主题鲜明，问题前沿，交流深入，成果丰富，达到了预期的效果和目的。我谨代表论坛主办方中国国际经济贸易仲裁委员会、解决投资争端国际中心和中华全国律师协会，对与会各位嘉宾、专家学者、协办方、支持单位以及所有为论坛成功举办做出辛苦努力的朋友们，表示衷心的感谢。新冠疫情作为国际关注的突发公共卫生事件，对国际仲裁事业的影响是深远的，甚至可以说是一个重要的拐点，将会推动新一轮国际经贸规则的改革或重塑，进而带动国际投资争端、国际商事争端解决机制的改革或重塑，影响世界上主要商事仲裁机构仲裁规则的修订或完善，特别是疫情下国际仲裁线上开庭形式的广泛应用，对传统的仲裁地法理论、临时仲裁理论等等提出新的挑战。疫情也让我们更加清晰地意识到，人类社会是利益共同体、责任共同体、命运共同体。世界各国相互依存、 命运与共，任何国家都难以独善其身，唯有团结合作才是正确的选择。国际仲裁界同仁也需要秉承人类命运共同体意识，和而不同，美美与共，在差异中寻找促进合作共赢的最大公约数，汇聚推动国际仲裁事业发展的正能量。今天参加论坛的有很多国际友人，很多朋友们也是中国国际仲裁事业发展的亲历者、见证者，甚至是参与者。希望大家继续关注和参与中国仲裁高峰论坛，继续关心和支持中国国际仲裁事业的发展。我们相信，随着中国国际商事争端解决机制多元化建设的不断推进，中国国际仲裁必将为促进国际商事争端公正高效解决，营造稳定、公平、透明、可预期的法治化营商环境，并对推动全球治理的法治化做出应有的贡献。感谢大家，期待与各位下次相见，谢谢。
谢谢俊峰会长。最后，有请中国国际经济贸易仲裁委员会副主任兼秘书长王成杰先生致闭幕词，大家欢迎。
尊敬的各位嘉宾、女士们、先生们、朋友们，大家好。春华秋实，暮色风尘。2020年中国仲裁高峰论坛在全球仲裁法律界线上线下热烈研讨和踊跃参与下，取得了丰硕成果，即将落下帷幕。在此，我谨代表贸仲，向出席本届高峰论坛的各位嘉宾、各位朋友以及支持本次活动的机构表示真诚的感谢。本届高峰论坛面向全球，聚焦疫情下国际仲裁前沿热点问题，邀请中国最高人民法院、贸促会、商务部的领导，以及联合国贸易法委员会、国际投资争端解决中心、国际商事仲裁理事会、国际仲裁机构等16个国家和地区的国内外仲裁法律界35位专家发表了精彩演讲，对疫情下建设友好性司法环境、国际争议解决及抗疫国际合作、共建“一带一路”仲裁机制、线上开庭实践创新等议题进行了深入探讨。与会专家一致认为，面对经济全球化的发展趋势以及全球疫情蔓延的重大影响，国际争端解决面临新的变革和挑战，其中不少问题需要国际仲裁界同仁凝心聚力，共同应对。会议就加强疫情下国际仲裁交流、深化务实合作达成了积极的共识。本届论坛是自2015年举办以来规模最大、范围最广、影响最深远的会议。论坛以全球同步直播的方式，吸引了来自近40个国家和地区的全球线上。我想请大家猜一猜，今天通过各种方式来关注这个在收看的人员数量是多少？能不能猜到？不猜到，我跟大家介绍一下。全球线上通过央视频、微博、Zoom、YouTube 等方式关注和收看论坛的人员超过140万人。各位专家对疫情下国际争议解决的深刻思考，对于当下及后疫情时代国际仲裁发展具有划时的重要意义，实现了共商对策、共启前景的预定目标，践行了贸仲创办中国仲裁高峰论坛这一高端交流平台的初心使命。各位同仁， 在本届中国仲裁高峰论坛即将结束之际，请允许我再次向各位专家与会嘉宾表示诚挚的谢意。感谢本届中国仲裁高峰论坛主办方国际投资争端解决中心、中华全国律师协会的大力支持，感谢中国仲裁周各主办单位的通力合作。在此，我还要感谢本届中国仲裁高峰论坛赞助商踊跃的参与和大力的支持。女士们、先生们，当前新冠疫情在全球蔓延，使世界经济的不稳定性、不确定性更加突出，贸易和投资争端加剧。仲裁作为化解国际贸易投资争端的重要方式，必将在当今时代发挥重要作用。我们愿与国内外仲裁界一道，积极推进国际仲裁深化合作，将合作愿景转化为切实行动，共同创造国际仲裁发展更加美好的未来。现在我宣布，2020中国仲裁高峰论坛圆满闭幕，祝各位身体健康，工作顺利，明年再见。